Senator Salazar.
Privilege, Mr. President.
Granted.
Thank you, Mr. President. Members of the body, I just wanted to show you something. These are pieces of stone that are being designed. It says State of Wyoming State Legislature. These are in stone. And also glasses, State of Wyoming State Legislature. They are only selling to state legislators, and they are in the lobby if you have any interest, and I just thought I would bring that to your attention. Thank you, Mr. President.
Perfect. This is sales week in legislature. Belt buckles are on sale as well. Signing and enrolled acts. Senate Enrolled Act 68, originally being Senate File 97.
Senate Enrolled Act 68 being original Senate File 97, Education Trust Fund Transfer, an act relating to the Wyoming Education Trust Fund.
I'm about to sign Senate Enrolled Act number 68, originally being Senate File 97. I have so signed. Senate Enrolled Act number 79, or Senate Enrolled Act number 69, originally being Senate File 79.
Senate Enrolled Act 69 being original Senate File 79, Plan of Safe Care Newborns, an act relating to public health and safety.
I'm about to sign Senate Enrolled Act number 69, originally being Senate File number 79. I have so signed. Senate Enrolled Act number 70, originally being Senate File 100.
Senate Enrolled Act number 70 being original Senate File 100, Designation of Spouses, Revocation upon Divorce or Annulment, an act relating to wills and probate.
I am about to sign Senate Enrolled Act number 70, originally being Senate File number 100. I have so signed. Senate Enrolled Act number 71, originally being Senate File 116.
Senate Enrolled Act number 71 being original Senate File 116, Protection of Lawful Commerce in Firearms, an act relating to civil procedure.
I'm about to sign Senate Enrolled Act number 71, originally being Senate File 116. I have so signed. Senate Enrolled Act number 72, originally being Senate File 169.
Senate Enrolled Act number 72 being original Senate File 169, State Shooting Complex Task Force, an act relating to the administration of government.
I'm about to sign Senate Enrolled Act number 72, originally being Senate File 169. I have so signed. Senate Enrolled Act number, House of Representatives Enrolled Act number 70, originally House Bill 103.
House Enrolled Act number 70 being original House Bill 103, Political Party Affiliation, Declaration, and Changes, an act relating to elections.
I'm about to sign House Enrolled Act number 70, originally being House Bill 103. I have so signed. You paying attention to that, Sherry? House Enrolled Act number 71, originally being House Bill 9.
House Enrolled Act number 71 being original House Bill 9, Juvenile Courts Concurrent Jurisdiction Clarification.
I'm about to sign House Enrolled Act number 71, originally being House Bill number 9. I have so signed. Messages from the House.
From the House of Representatives, February 27, 2023. Message number 8, override governor's veto failed. Mr. President, the House has sustained the governor's veto on House Enrolled Act number 33, being original House Bill number 106. Ayes 38, noes 24. Message number 453, concurrence failed. Mr. President, the House failed to concur on Senate amendments to House Bill 144, Senior Citizen District Programs and Services. Ayes 22, noes 40. Message number 454. Mr. President, the House appointed House conferees to meet with the Light Committee Number 1 from the Senate on amendments to House Bill 144. House Representative conferees are Representative Strzok, Chairman, Representative Banks, and Representative Crago. Message number 450. Mr. President, Senate File 96, Omnibus Water Bill Planning and Administration, passed on third reading in an amended form. Ayes 60, noes 2. House respectfully asks the Senate to concur by adopting amendments. Message number 455, concurrence passed. Mr. President, the following bills the House did concur on Senate amendments. Ayes 44, noes 18 on House Bill number 276, Shed Antlers and Horns Conservation Stamp. Message number 451, House Bill number 2, Town Officers Salary Waiver, Ayes 62. Message number 452, House Bill 99, Property Tax Refund Program, Ayes 50, noes 12. Signed, Katie Talbot, House Chief Clerk.
Messages from the governor.
From the office of the governor to the Honorable Ogden Driscoll, President of the Wyoming Senate, on February 24, 2023. RE, veto of 2023 Senate Enrolled Act number 37, Senate File 71, originally, State Loan and Bond Programs. Dear President Driscoll, dispensing with further reading, signed, Mark Gordon, Governor.
Thank you. So body, pay a little attention. We've got the letter. This bill came unanimous, last one vote out of this body. Down the hall was unanimous. The governor chose to go ahead and override it. Senator Hicks, Majority Floor Leader Hicks, will give you a little more explanation. And then we're going to go ahead and go into a veto override motion on this one. And I would hope that the body could stand tall with the way we came. Senator Hicks.
Mr. President, so this was a joint appropriations committee bill that we looked at, and the idea behind the bill was to start to reduce the public purpose investments on the Permanent Mineral Trust Fund, and then we also had another one. But what this deals with specifically was a number of these entities, but the governor's veto message deals strictly with the ag loan program. And it was the feeling of your joint appropriations committee that as we currently have it, there's over $275 million allocated, and the PMPF is a public purpose and investment. The SLIB could actually lend that much out for farm loans. And so what we looked at is we looked at the historical usage of that program, and I think, and I don't quote me right now, Mr. President, but it's been really low, particularly in the low interest environment. There is still a few farm loans out there which would beg the interest. Is why they didn't refinance, I don't know. But what we tried to do is reduce that down to 50 million, still allow those ongoing obligations, and allow up to 2 times the current utilization. So there's still enough with $50 million. If we doubled the amount of people that came in and were eligible for farm loans, there's still that $50 million in there. We can come back at any time, any session, and raise that up. And so that was the rationale of your Joint Appropriations Committee. We felt that the 50 million allowed for the opportunity for double the amount of utilization that's currently there. If we saw more of that, that we could come back and change that as we needed to, instead of leaving that $225 million parked there with an obligation against it to free that up. The governor agreed pretty much with that component of it, but where he found exception to it is what the Joint Appropriations Committee was tasked with doing is trying to find out what's a reasonable interest rate that the state should charge on these loans. And one of the problems that we've always historically had, whatever interest rate we set now will be the interest rate 10 years from now. And so it's very difficult for us to come back and look at every one of these programs that we provide interest rates in. So what we tried to do is say, look, because it's an ever-changing target, we indexed it to US government treasury bills as to whatever the closest term of the loan was. In other words, if you did a 2-year loan, you would be indexed to a 2% treasury. If you did a 10-year loan through SLIB, you'd be indexed to a 10-year treasury. Next year, that's going to change. So it's a fluctuating interest rate based on what the market rate is. And then we also included a provision in there that SLIB could charge up to a 2% risk premium on top of whatever that index US Treasury rate was. And so what the governor's veto is said he felt like that might be competing with the private sector, that we set it at whatever that, say, if it's a 10-year note, 10-year Treasury plus 2%. Today, Mr. Chairman, that would roughly be about, I believe this morning, the 10-year Treasury was running about 3.8 or 3.9% too. It'd be 5.9% on a U.S. government Treasury rate. We know 2 months from now, if the Fed meets again, they're going to raise that, so that would go up. So rather than that fixed interest rate, we either charge too much or we're charging too little. This is indexed and allows that. Now keep in mind, SLIB reviews every one of these, and they have the ability to deny these loans. So it doesn't take that away from the SLIB board one iota. It just says if you're going to grant them, this is the way the interest rate will be calculated going forward. We thought it was the easiest and fairest way that it reflect what the market is, Mr. Chairman. I think you, as you indicated, this was a almost unanimous vote out of here and almost a unanimous vote on the other side. And it was a work of a lot of the Joint Appropriations Committee. And so, Mr. Chairman, that's an explanation of what the rationale, I think, behind the chief executive's veto was. And now it's up to us to decide, Mr. President, whether we want to override that or sustain it. So do we want to have any discussion, or do we want to just go for the motion, Mr. President?
Mr. Chairman, I'd like to go ahead and do a little bit of discussion.
All right.
We're well within the rounds to do so.
So, Mr. President, there was a question back here, and it was the original Senate File 71, State Loan and Bond Programs. So if you've got access to that, you can either pull it out of your drawer or up online, and we're going to have a little discussion on that. If you go to the website, it also has a 3-page explanation of the governor. And, you know, a lot of it's the historical context. This program was set up as a lifesaver in the 1980s when we were facing double-digit interest rates and people couldn't even borrow money, and it was a lifesaver. The program still exists. We've just reduced the maximum amount down to 50 based on the historical utilization. And we've indexed the interest rate plus the 2% premium on there that would be charged. And so what we didn't want to do in Appropriations Committee was provide an interest rate lower than what the rate of return was on the Permanent Mineral Trust Fund, because then now we're subsidizing below what the market rate. And so historically, that's been part of the problem. When we set one interest rate, we don't come back and adjust those periodically, like maybe on an annual or biennial or every 4-year basis. You're either before or below the market. So this was what the Appropriations Committee thought was the best way to handle that issue. We're not going to lose any money by lending this out. In fact, with the risk premium, we might make a little bit of money on this. The idea was that we would never lose whatever, if our PMPF was invested in fixed income, which is treasuries, and we have a significant amount of that in fixed income, this would be comparable to what we're currently investing those funds for. So, Mr. Chairman, that's a further explanation, and I guess I'd stand for any questions.
Questions, Senator Case.
Thank you very much, Mr. President. I'm picking up on some things that I didn't pick up the first time through this, but I refer to His Excellency's message in the last paragraph on the second page. It says, generally, I support the notions of this bill. However, the changes this bill would make to interest rates for farm loans would put the state in direct competition with private financial institutions. This is not the proper role of the state. I realize the current interest rate for farm loans as stated in statute is 4% to 10%, and the lower end of the range would currently compete with the private sector. Nevertheless, under current law, the State Loan and Investment Board set the rate for farm loans by rule at 8% or 9%, depending on the ratio of the loan to the appraised value. By doing this, the SLIB established an interest rate which would provide farmers a viable option when interest rates are excessively high, but avoid competition with the private sector when rates are reasonable. The new rate created by this bill does not give the SLIB the flexibility to create a rate which would not compete with other lenders when rates are reasonable, yet be available when interest rates are excessive. This program was never intended to compete with banks or mortgage companies during ordinary times, and so I cannot support the changes in this section of the bill. I'd like to learn more about that, Mr. President. That seems significant to me as being a supporter of the private sector and private sector banking. I'd like to know more about that issue.
Senator Scott.
Mr. President, and let me second that request. And specifically, what I'd like to know is what kind of an interest rate would they be able to charge on the farm loans? I will say the governor's description of it as a lifesaver in time of high interest rates is accurate. Frankly, my family's ranch had one of these for a while, and it was very, very useful to have. We've since gone away from it and gone to private lender because the rate was better and we no longer needed the protection that the state rate afforded. What I want to know is, with the formula, I haven't been able to figure out what it would be, not knowing what the rate on the permanent funds, that is your reference point. I don't know what that is. And if it's in the 6.5% range, then you add 2% risk premium, be up to 8.5%. That, Mr. President, would be reasonable. It's right in the rate that areas that they are now. But if it's significantly lower than that, then they would start to be competitive with the private. And the private market is perfectly good at this time. So I didn't declare a conflict on this going through. I don't expect to ever need one of these again, but it was very valuable when it was available, Mr. President. So potentially an important program, but it should not in normal times be aimed at knocking out the private lenders. I think that's in general better than a government approach. So, Mr. President, to vote intelligently on this, I need to know what the farm loan percentage rate is likely to be if this bill should become law.
Senator Rothfuss.
Thank you, Mr. President. In the interest of understanding this, I think it's important that we have a little freer debate and don't limit the majority leader to 2 times speaking. So with that, without objection, I would request that the rule on 2 speeches, the limitation on 2 speeches, be suspended for the purpose of this debate alone.
I'm going to grant that. I hadn't even considered it. Senator Rothfuss, would you come to the desk?
Any further discussion before we go to President Driscoll? Seeing none, President Driscoll.
Thank you, Mr. Chairman. I guess I'm going to go back into the bill. I'm looking at the footnote he used to cite it, and I'm not sure I read the bill exactly the same. As we go through this, the way it was, I'm going to wander just a tiny bit. Page 7, when you look at the old language in this bill, Mr. President, or Mr. Chairman, the stricken language was, shall be at an interest rate of 1% plus 75 thousandths of 1% for each year of the loan in excess of 5 years. And what they did was entered in equal to the yield on a United States Treasury security, the same duration loan. Board member add an additional percentage not to exceed 2% as a risk premium to the interest rate established under this subsection. Rate interest for all loans entered under this section shall not be less than 3%. When you look at what the Fed's done, folks, Mr. Chairman, they're not very competitive right now. If you add 3% at a base on the thing on top of the Fed rate, I believe, and I haven't looked today, but I think you're pushing 7 something. That's probably the base of it. The very lowest would be kind of competitive with bank rates, but if they add the other couple percent they can add to it, they're probably just out of the market, and we're actually leaving a program out there that does do what may happen the next year if the Fed increases another 1.5%, 2%, which I don't necessarily anticipate to happen, but it appears it could, looking at what's going on. Now you're back to farm loan rates that are pretty onerous for anybody that's out there. And these sections are pretty much the same on the way they've done it. They've all pegged them to federal securities at a minimum of 3%. I actually am not positive, and I'd like to see if someone reads it different. I think the governor looked at it at 3% and said, we're doing them at 3%, because when you go to the fiscal note, it says bill amends interest rates be equal to yield of United States Treasury security of the same duration loan, but not less than 3%. Farm loans, beginning ag producers, farm loans, infrastructure loans, street and road projects. 2% is a risk premium on it. Well, when you go 3% plus that and you add 2%, I think you're probably, you might be close to some bank loans, but I think you're actually above them. So I think it's worthy of an override, and I think we're clearly there. If it's that cheap, the other point I would point out is it's no longer 275 million. There's 50 million bucks. If it's that competitive, it's probably gone by next year, and we're going to deal with it anyway. So I don't see this as nearly the sky has fallen threat that would warrant a veto that maybe was there. And it's going to take people a while to figure it out, other than maybe what we're talking. I stand for questions. Thank you.
Thank you, Mr. President. Senator Kinski, to you.
Thank you. This is not just the work of the last interim. This goes back clear to when I first came into the legislature and I was on management audit. And we were trying to figure out what to do about these loans that are being made out of the Permanent Mineral Trust Fund. We've got a Permanent Mineral Trust Fund that's supposed to be inviolate. And then over the years, we had these series of loans that were set up at below the rate that the fund was earning, bargain loans that either entities would get or borrowers would get, which to me is an indirect way of making an appropriation out of the Permanent Mineral Trust Fund. Absolutely is an invasion of the Permanent Mineral Trust Fund. I think it violates the spirit of it. The purpose of those loans was this: in the case of private enterprise, when the free market dictates an interest rate like this, you can borrow at a much lower rate out of the PMTF. Now, we haven't had that problem of late. And this particular program, the farm program, is massively undersubscribed. Hardly anybody's using it. The other one, like $400 million for communities to borrow for anything at an interest rate that is just a smoking deal. It's like 2.5% over 25 years. Who gets that? And it's because you just can't resist the impulse to reach into that PMTF and make some of these bargain loans. Well, now if the whole purpose of this bill is to back off some of those obligations, is to reduce the maximum amounts, like that one that's $400 million. How do you invest that money when you don't know who's going to come in when to start borrowing on it? So you end up keeping it in short term. You end up keeping short term, and you're cheating the taxpayer. Because if you freed this money up by limiting these public purpose loans, then you could invest this money for the long term and earn 5 or 6% instead of what you'd get on short term money. So it's not just farm, but it's a whole host of special interests that over time, political subdivisions have gotten into this, into the PMTF. And what we've done is where the limits were way too high, but we didn't want to eliminate the program, we lowered those limits. Some of them, we sunsetted the programs. And in the case of all of them that we maintained, we said, let's set the interest rate at something that's like a market interest rate to avoid competing with the private sector. Because frankly, these are all supposed to be below market interest rates. It's just that the interest rates in the market have been so low lately that nobody's really been taking advantage of them. So I would urge an affirmative vote to keep this bill in place, to override the veto, and let's protect the Permanent Mineral Trust Fund from all these special interest loans. Thank you, Mr. Chairman.
Senator Rothfuss.
Thank you, Mr. President. Mr. President, I think that it's reasonable to look at the two different issues here and have divergent opinions. The idea of the interest rate floating at a specific rate relative to the market, which might be overly aggressive and potentially hinder our banking community. I think that's a reasonable concept, and I think that engagement in competition could potentially be problematic. Mr. President, I don't have a sense, honestly, of whether we set it overly aggressive, under aggressive. I really haven't gleaned that yet, to be quite honest, from the testimony or from an understanding based on the broad range of farm loans of whether this will look like a good deal or not look like a good deal if we pass this bill. Excuse me, well, we did pass the bill if we override, though, and make that decision. The point, though, that seems very clear and unambiguous is, first of all, this isn't being used now appreciably. There's very little utilization over the years. And second of all, the major policy that I see through this Senate Enrolled Act 37 that was attractive to me and was the reason for my support was scaling back the size of the loan from $275 million to $50 million, and thereby encumbering effectively $275 million of Permanent Wyoming Mineral Trust Fund, which can't then be invested strategically. I mean, it's still being invested, but certainly not with a long-term strategy. As a result, we're losing literally millions of dollars a year. I think it's important to realize that. If there's a 2% differential, and it could be worse than that, I don't know where we're encumbering these. If we're encumbering these in the agency pool and we're pulling in around 2.1% relative to our permanent investments above 5%, maybe even 7%, we could be losing 5% yield on $200 million. That's $10 million a year, and nobody's using this program. This program has cost us, for the entire time we've been using it, or not using it, as the case may be, about $10 million in lost opportunity cost to have the convenience of having it there when nobody's utilized it. So, if there is a problem with the interest rate, which there might be, I think it's still important for us to override this veto, to save ourselves, or rather increase our revenue by, I'll say, $5 to $7 million over the next year, and then really come back, ask CapFin to take a look at that interest rate during the interim, and maybe come back with a better approach, which I think is perfectly reasonable. But it's important that right now we shift from $275 million to $50 million as quickly as we possibly can, and then gain the revenue off of that de-encumbrance, if that is a word, Mr. President. So I think it's appropriate for us to override this veto and then honestly work with the executive branch through the CapFin committee and figure out if there is a problem with that interest rate in the long run.
Further discussion. Senator Barlow.
Thank you, Mr. President. So the second part of the bill talks about the 400 million, which has been reduced to 175. So therein lies another $225 million that we would get that improved return on. My question is, what kind of encumbrance is currently on that political subdivision loan program? Thank you, Mr. President.
Senator Hicks.
Mr. Chairman, when we run through the analysis on this, what we had is the secretary or the state treasurer come in there and they would show us the historical utilization of the program. How much was outstanding, how many obligations we already had. I can't specifically answer how much in each one of those programs, but what we did is we looked at that historical utilization, how much our obligations is, and then left what I think is a very conservative buffer point for those programs that we didn't sunset to move forward. So that's the analysis that we went in, and so that's the numbers. I can't tell you exactly what that utilization is. I'd have to go pull that data back out, but that's the process that we went through. How much is encumbered? How much has been utilized? How much do we need to leave in there for a buffer? So these programs that were like farm loan, and keep in mind, the bill's much broader than just farm loans. That's where the governor tend to focus on. One of the other issues that we came up with is so you look at it, one loan has a different interest rate than the other. So the Farm Loan Board says 4 to 10%. By rule, they've done 8 to 9, but yet if we look at dormitories and streets for counties and towns that could borrow against it, that's 1% and 7 or 0.75% up to 5 years maximum loan, which comes out to about 4.75. So you had all these different variable loan criteria with every different program that's an incumbent on the permanent fund. And then we said, well, one of the things we need to standardize that, whether you're borrowing it for farm loans or you're borrowing it for dormitories or you're borrowing it for roads and streets at the county level, you should have a standard rate. Everybody should have to play by the same loan requirement games. And so this brings in and makes this uniform for all of those obligations out there. But specific to my colleague's question, I hope that answers it. That's the formula that we went through to calculate how much to reduce those obligations by and leave that buffer in there.
Thank you. Any further discussion? Senator Scott.
Well, Mr. President, it does seem to me that we shouldn't automate the various loans to the political subdivisions into our university in the same, and supply the same interest rates to ones that would compete with the private sector, that are private sector loans. I think it's appropriate to give some discount, perhaps, to our public entities. Mr. President, I'm continuing to have troubles with this because I think, we say that the farm loan program has not been utilized. But if this formula that's in here is going to result to a loan that's in the 5 or 6% range, you won't see no utilization. You'll see a great deal of utilization. And the governor will be proved to be right. And maybe we ought to sustain his veto. If it's going to be, if the loan rate with the formula here, and I can't tell, is going to be back up into the 8.5%, you'll continue to see very little utilization and shouldn't see utilization. And Mr. President, I'm inclining to sustain the governor unless I can get some answers as to what this is really going to do. Where's the interest rate on the farm loans going to be? Is it going to be up where I think they're properly set now, or is it going to be a drastic reduction? The governor seems to think it's going to be a drastic reduction. And if so, is that going to cost us more than the other improvements in the bill?
Further discussion. Senator Hicks.
Mr. Chairman, I'll try to answer that question, and quite frankly, I need a little bit more information because this still allows SLIB to go through. This is supposed to be a lender of last resort, so they still have the ability to make rules. Now, that would be the interest rate, but I think what they would have to demonstrate at some point in time that you're not the first lender of resort. And I think they can do that through their existing rulemaking process, and quite frankly, that was kind of what was portrayed is when somebody comes in, you don't just lend money because somebody submitted an application. If you're a bad risk, you're a bad risk. And so the staff goes through and looks at those things. So specifically, I don't know whether SLIB would be able to say, look, under our criteria or rulemaking, we're the lender of last resort. We don't have to accept an application just because we have a lower interest rate. I believe that's the way it works, Mr. Chairman, but I would have to get more information to absolutely confirm that. So, but I believe that was the way it was portrayed to us. It's always intended to be a lender of last resort.
Further discussion, Senator Landon.
Mr. President, thank you. Really appreciate all of the dialogue on this one. It's helping me a great deal. I'm still struggling though, and I might be the only one, I bet not, at trying to understand the intersect point with where the concern comes in that we're competing with the private sector. And I'm struggling to get there. You know, what needs to take place for us to run that risk? Because we have always been very careful on that front in the Wyoming Senate. So if we could kind of drill down into that a little bit and help me understand what's going to take place with the outside loans and where is that intersect point? Thank you, Mr. President.
Senator Steinmetz.
Thank you, Mr. President. I can't answer that last question, but I did want to I can't get to all the documents and handouts that we saw in the interim right away, Mr. President, but just so you're aware, the balances we're dealing with as of April 30th, 2022. So the current outstanding balance of the Wyoming Farm Loan loans was $16,719,000 a few odd dollars. There were a number of open loans, 39, and the repayment on that is around $15 million. There was another 5 farm loans with about $1 million there, $889,000. But the available balance for future loans, and that's the part that we're encumbering and saying in the Permanent Mineral Trust Fund we have to keep somewhat liquid, is $257 million, 311,000 and some odd change. So, I mean, $250 million, that's a lot of money. So we're proposing getting that down to that 50 million, and that's still way more than we need. And that's just the farm loans. That's not the Joint Powers Act. That's not all of the other things that we're, now I would say if we could come back and tweak this if we find out it's not working. But the cost, the opportunity cost that we're losing by encumbering all this money through these loan programs is enormous. And so it's a part of our cleanup, the total return policy that we're moving toward. And I would urge us to override this veto. Thank you.
Further discussion. Senator Furphy.
Thank you, Mr. Chairman. I just want to tell you kind of where the private markets are. Private markets are usually 200 basis points over Treasury yields for loans. So a current 5-year Treasury rate is at 4%. So add 2% to that, that'd be a 6% rate. That's what the banks are probably lending right now. Municipal bonds, which the state wouldn't care about that because not taxable equivalent, but a tax-free bond right now for 5-year yield is 2.64%. So that's what we would be competing against, Mr. President. Thank you.
Thank you. Further discussion. Senator Rothfuss.
Thanks, Mr. President. I just wanted to stress once again that I think a lot of the focus is on the interest rate and the lending side. And I think that's the spirit of the veto, is that space. I think that's the lesser space to worry about. And that's why I support the override. The encumbrance of, looks like $250 million, I underestimated it a moment ago. The encumbrance of $250 million is really, really bad policy. And that's what this bill does is clean that up. And I'm not entirely sure where the rates would end up being set if SLIB would end up with a better rate than what the good senator was discussing at 6%. It doesn't sound like it. It sounds like they would come up with an inferior option. The original intent of the statute, again, was to try and get to the circumstance where rates were very high. Imagine a circumstance where rates were 10, 12%, and the state was offering a high-quality 7% farm loan or something along those lines, right? That's the intent. But, Mr. President, we're not in that time right now. We're not in the space where we have to really worry about these loans being utilized over the banks. And again, if there is a problem, there's plenty of time and plenty of opportunity for CapFin to work through that and address it. The urgency and the high priority is unencumbering the $250 million so that we can make the extra $5 or $10 million a year. And you think about it, we have $16 million of total loans. $16 million of total loans, it's costing us perhaps $10 million a year for the privilege of providing $16 million of loans. You know, no financial business would last very long if it were operating in those conditions. I don't know how we found ourselves in this position, but I'm appreciative, honestly, of the CapFin committee for discovering that we need to remedy it and bringing a solution. So while I do sympathize with the governor's concerns in his veto letter about not competing with the banks, and I think we should work more on that to ensure that we're not, the priority is removing the encumbrance on the $250 million so that we can be providing the appropriate amount of return on investment to the Permanent Wyoming Mineral Trust Fund, which is the property of the people of the state of Wyoming. And we are not acting as sound fiduciaries for that $250 million, in my view. So with that, when the motion comes, I believe we should override the veto.
Is there another comment?
Thank you, Mr. President. I think as we all have said, and as everyone has communicated and understands, including the governor, the amount of earnings that could be achieved if this bill were to pass. I think the hesitation that we're all struggling with, of which we simply don't know the answer to because the governor didn't provide, as to why he was unable to make this cost-benefit analysis, which is quite frankly unequivocally clear that it is more in line with our fiduciary responsibilities to allow these funds to be invested consistent with our total return policy as opposed to continuing to have them be encumbered for concern over this interest rate, which is a legitimate and fair concern, but certainly something that the committees of the legislature can work towards in the interim and certainly provide stronger solutions next year, meanwhile not allowing hundreds of millions of dollars to go uninvested. So to me, on balance, I mean, it's not even a question, except for our good chief executive, who is learned in these matters, takes a different opinion. That said, we are the legislature, and I believe we override.
Senator Scott.
Well, Mr. President, let's look at the math a little bit here. We do set aside, and I suspect the reasons go back to when the permanent fund was much smaller. We set aside a large amount for potential loans, even though it looks like we'll never make them. And yes, that's unfortunate. I'm not sure, I don't think that's legislative. I think that's administrative practice that was probably wise once, and once it got set, it never gets changed, so we need to undo that. So you have the possibility, if this veto is sustained, of another year of setting aside too much money and getting a lesser return on it because of it. On the other hand, you make these farm loans super competitive with the banks. You might not see 50 million in loans outstanding, you might see 150 million. Or it's even a much smaller figure than that right now. You add another 100 million in loans and they're outstanding for a much longer period, like 10 years, Mr. President. you lose 2 or 3% on that for a period of 10 years, because you'll have contractual obligations once you've made the loans. You're starting to talk about perhaps even more money than we're saving. So the governor's got a point here, and I think we need to think about it pretty hard. And it's hard to do the math not knowing all the variables right on the spot. But it may be that this bill is going to cost us more than we're going to improve our yields. Mr. President, I am quite concerned about this.
Senator Kinski.
If I'd had my way, we would have eliminated all these programs. Why are we in the business of making loans out of the permanent mineral trust fund at all? It is the permanent mineral trust fund. We should not be making loans out of it. But I didn't get my way. We cut these programs back. We lowered the maximums, in some cases, just to the maximum loans that were already out. With the hope, I hope, of sunsetting them at some point. I would have just said, anybody who's already got a loan, you're grandfathered, and we're going to get rid of the rest. Couldn't get there, but this bill is a great improvement over what is in current law. Why are we making bargain interest rate loans to political subdivisions? You know, go out on the bond market. That's what I did when I was in charge of a town, is I went down and went on the bond market. But these loans compete with the bond market. The bond market's the free market. We are now competing against the free market because you can borrow out of this at 2.5% on a 25-year loan. That is what we're putting a stop to, competing against the bond market there. Let's talk about farmers. First of all, I love my ag producers, but all my years in business, nobody set up a bargain interest rate program for me out of any government fund. I had to tough it out. These two programs are set up to be below interest, below free market rates. The farm loan program shall never be more than 10%. The reason that's there is, remember the days when loans went to 12 and 15%? This was intended to make it cheap to borrow, to compete against private banks. The young farm loan, it will be the lowest of 8% or the yield on a 10-year treasury. If a 10-year treasury is 8, you get it at 4. These programs are set up to be below market interest rates. And what we're saying is, no, we're going to reset the interest to something that's a little more fair. Fair to the taxpayer, fair to the fund, and fair to private lenders, frankly. Why would you ever borrow from the bank at 12 when you can get out of the permanent mineral trust fund at 10? Why would you ever borrow from a bank at 8 or 9 when you can get a young farmer loan at 4? So the first is just philosophically, whether you're in ag or any other industry, should you be able to borrow at bargain interest rates? I say no, but assuming that you like the idea, should you be able to do it out of the permanent mineral trust fund? It's a trust. On and for the override. Thank you, Mr.
Senator Rothfuss.
Thanks, Mr. President. I just wanted to address the Tall Senator from Natrona County's concerns about the possibility of expanding the program and expanding the loans. There are two provisions that are changed. Well, they're changed several times, but two concepts that are changed by the bill. One is the approach to calculating an interest rate. That would statutorily be changed. We've discussed that. The other is changing the caps, the amount of money that's available and therefore encumbered. So as an example, for the farm loan program specifically, it is capped at 50 million. You can't lend out that 51st million. And you see changes to the available funds also for joint powers boards, for municipalities, where in current statute, you have hundreds of millions of dollars available. With the past legislation, those are trimmed back dramatically, and it therefore decreases, unquestionably shall decrease, the amount of funds in the Permanent Wyoming Mineral Trust Fund that are encumbered. So it is not a question mark on that side. While the rate of the loans, Mr. President, may be a bit of a question mark. There is no question mark to the amount of encumbered funds and the changes associated with this bill as they relate to those amounts moving forward. So there is no question that this legislation will mathematically reduce the obligations on the state and will increase the amount of funds that are available for long-term investment, thereby creating additional revenue to the state. That is clear and true. So with that, again, supporting the override.
Other questions? Ready for the motion, Senator? Mr. Majority Floor Leader.
Mr. President, pursuant to Article 4, Sections 8 and 9 of the Wyoming Constitution, I move that the Senate override the governor veto of Senate Enrolled Act Number 37, being the original Senate File Number 71, State Loan and Bond Program.
The motion to override the governor's veto of Senate Enrolled Act Number 37, being original Senate File Number 71, is in order. The vote to override is debatable and requires a two-thirds majority of the members elected. Any further comments?
Question.
Question being called. Senator Scott.
Mr. President, the previous comments by the minority floor leader have got me convinced we aren't going to have a runaway here. I think there is a problem we're going to need to fix with future legislation. But I think we can safely override this one and then deal with the problem. I think there is a problem here that the governor is pointing to in the future.
Question being called. See no further debate. The motion is to override the governor's veto of Senate Enrolled Act Number 37, being original Senate File Number 71. Chief Clerk will call the roll. It'll take a two-thirds to override.
Veto override of Senate File 71, Senate Enrolled Act Number 37. Anderson? Aye. Baldwin? Aye. Barlow? Aye. Beitman? Aye. Boner? Aye. Bouchard? Aye. Brennan? Aye. Case? Aye. Cooper? No. Dockstader? Aye. Ellis? Aye. French? Aye. Furphy? Aye. Garou? Aye. Hicks? Aye. Hutchings? Aye. Ide? Aye. Jones? Aye. Kinsky? Aye. Cole? Aye. Landon? Aye. Larson? Aye. McEwen? Aye. Nethercott? Aye. Pappas? Aye. Rothfuss? Aye. Salazar? Aye. Schuler? Aye. Scott? Aye. Steinmetz? Aye. President Driscoll?
Aye.
Aye. Closing vote. Closing. Vote closed on the veto override. 30 aye, 1 no.
Even I can figure that percentage. By your vote, you voted to override the governor's veto of Senate Enrolled Act Number 37, being original Senate File Number 71. Senator Cooper.
Thank you, Mr. President. Privilege of the floor, please.
Granted.
Ladies and gentlemen, I'd like to introduce you to a young man here today. Eli, would you step up for this? Mr. Eli Mitchell. You'll see in his hand he's sporting a brand new West Point hat. Eli is our appointee from Tinsley to West Point. He'll be going out there in a couple months, and I'd like to just have him recognized as such.
Eli, that's a heady honor. Congratulations. Mr. Majority Floor Leader.
We get our West Point candidate maybe to say a few words to the Senate?
I was about to invite him to do that. Step up to Senator Steinmetz's desk and fire away.
I'd like to say thank you to those who made it possible to do this and to the representatives in the United States Congress that nominated me for this position.
Hey, here. We expect you back in a couple of years in uniform. Come see us on break. Have a joint conference committee to appoint. Joint conference number 1 to House Bill 144. Boner chair, Case, and Schuler. Senator Kinski.
Thank you. Privilege of the floor, if I may.
Granted.
Folks, you may have seen the announcement in your email, but I just wanted to reinforce that we are going to have a Senate mixer tonight at the Central Cafe from 6 p.m. to 8 p.m. It's being hosted. The last one was hosted by myself, Senator Boner, Senator Steinmetz, and Senator Ellis. This event will be hosted again. It'll be at no charge to you except for the drinks. You know, we can't, with this group, we can't cover the cost of booze. But you're welcome to come. It was a very nice event the last time. I don't know how much politics got talked. There was just a lot of talk about families and people and backgrounds, and it was a very relaxing event. I'd encourage you to come. Thank you, Mr.
It was a phenomenally nice event. Thank you for hosting. I attended, and it was quite nice, so thank you. Mr. Majority Floor Leader, we're at that order of business, consideration of bills on general file.
Mr. President, I move the Senate resolve itself into committee of the whole.
You've heard the motion. All those in favor say aye. Aye. Those opposed, no. Senator Landon.
Committee of the Whole will please come to order. Ladies and gentlemen, let's start our engines and take her to the finish line. What do you think? We've got some House bills to consider, and the first of those is House Bill 152. If the reader will please read the bill. Thank you.
House Bill 152, Life is a Human Right Act, sponsored by Representatives Rodriguez-Williams, an act relating to abortion. It was referred to committee number 5, which returned a committee recommendation that it do pass amended. Ayes, Senators French, Hicks, Ide, Kolb, and Steinmetz. Senator Steinmetz, Chairman.
You've heard the reading of the bill. What is your pleasure, Senator Steinmetz?
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report, it do so with a recommendation that House Bill 152 do pass, and I would ask that the Standing Committee amendment be read in at this time.
House Bill 152, Standing Committee Amendment Number 1 to engrossed copy, page 2, lines 13 through 15, delete.
Senator Steinmetz.
Thank you, Mr. Chairman. I move Standing Committee Amendment Number 1 to House Bill 152 and ask for your favorable consideration, and I will explain the House bill and the Standing Committee Amendment at this time. Mr. Chairman, our fellow senators will find in their inbox the amended version of House Bill 152 with the amendments tracked in from the committee. And so if they would like to follow along on that version at this time. I'd also like to thank the good tall senator from Natrona County that laid this bill back on Friday to give us longer to consider it and vet it properly. And I know that we all value human life, and we value our lives on the highways and getting home to our families on the road when we go home on Friday. So thank you to the good senator.
Thank you for that bill tracked in, and hopefully the senators have found that. Thank you, Senator
I hope
Steinmetz.
so. Thank you. All right. So to begin, I'll just take you on through the bill and tell you why we're bringing it. As you know, the legislature is taking the opportunity to provide a more complete statement on Wyoming's position of the protection of life since the overturn of Roe v. Wade. and this bill hopes to answer questions that the trigger bill could not. On pages 2 through 4, you will find legislative findings in this bill. In those findings, the body recognizes that because unborn babies are members of the human race from conception, they are entitled to the right of all humans. The body also recognizes that Wyoming has a legitimate interest and duty to preserve the life of all humans, no matter what stage of life they are in. The amendment basically removes findings 1, 4, 6, and 9 from the bill, just to clean that up. On pages 5 through 6, you will find the definitions portion of the bill. Abortion is defined as the intentional termination of the pregnancy of a woman. It is critical to point out that the bill specifically states at the bottom of page 6 to the top of page 6 that abortion does not include measures intended to save the life of a baby, measures to remove a dead unborn baby, or treatments for ectopic pregnancies. Pregnancy, reasonable medical judgment, and unborn baby are also defined on page 6. On page 7, this is where the prohibitions for abortions take place. 7 and 8 further discuss exceptions. Pre-viability separation procedures in order to prevent the death or serious permanent impairment of a life-sustaining organ of the pregnant woman is exempted. Treatments resulting in the accidental injury or death of an unborn baby, and contraceptives are not included in the definition of abortion and are not prohibited. This bill is centered on intent to destroy an innocent life. We have also amended to delete section B at the bottom of page 7 in the standing committee amendment, and we have amended to exempt rape and incest by the addition of Romanet III at the bottom of page 8 and adds a reporting requirement. Going on to pages 9 and 10, penalties do not apply to a pregnant woman who is the victim of abortion. Physicians or anyone who causes an abortion or to receive an abortion are guilty of a felony and a fine not to exceed $20,000. A physician may risk losing their licenses as well. That is on page 9 and 10. Pages 10 and 11 are the civil remedies. It creates a private right of action for women who are victims of abortions and provides a route for enforcement by a district attorney with proper jurisdiction. Pages 12 through 13 is how the act is to be construed and the right of intervention. You will also see there is an amendment on page 13. Pages 12 through 13 create standing for the legislature, and that amendment is there from the House Ag Committee. And that basically says, notwithstanding any other provision of law, a member of or members of the legislature who sponsored or co-sponsored this act shall have standing to defend the act as an intervener in any case in which the constitutionality of this act or any portion thereof is challenged in a court of competent jurisdiction. You will note that we have not given ourselves that in law before. We have in other areas of law for other people, but not for the legislature. However, some states around us have. Page 13 is the jurisdiction. Pages 14 through 16 are record keeping. It requires the Office of Vital Statistics to complete data on abortions committed within the state. Page 16 is protection for physicians who refuse to perform abortions. Page 17 prohibits state funds from being used to perform or abet in abortions. Page 19 deletes section 8, which makes a second trigger bill. That was part of the standing committee amendment. And the law is effective July 1st, 2023, and sections 7 and 8 are effective immediately. Mr. Chairman, that is the bill, and I would stand for any questions at this time.
Senator Steinmetz, do you want to deal with the standing committee amendment at this time? And then we'll go back to the bill.
Yes, if there are no questions on the amendment, I would call for the question on the standing committee amendment.
The question is on the standing committee amendment number 1 to House Bill 152. Are you ready for the question? All those in favor of standing committee amendment number 1 to House Bill 152, please say aye. Aye. Any opposed, no. Standing Committee Amendment Number 1 to House Bill 152 is passed. We are back on the bill. Senator Ellis.
Thank you, Mr. Chairman. There is a Committee of the Whole amendment. I'd ask that it be read in.
House Bill 152, Committee of the Whole Amendment Number 1 to engrossed copy, page 1, line 5, delete.
Back to you, Senator Ellis.
Thank you, Mr. Chairman. I move Committee of the Whole Amendment Number 1 to House Bill 152 and would ask you to vote aye. Senators, we've had a lot of good discussion this session about our constitutional requirements, and one of those that you're familiar with is Article 3, Section 27, which prohibits special and local laws. It has a list of enumerated instances where cases, where the legislature should be very mindful of its involvement in the functions of the judicial branch. It prohibits us from regulating the practice in courts of justice. It prohibits us from providing for changes in venue in civil or criminal cases. We are prohibited from exercising any authority when it comes to summoning or I can't read my own handwriting, summoning juries or changing any rules of evidence in any trial. And the goal of this is really to respect the judicial branch and their proceedings. But more broadly, it also prohibits us from taking any action where a general law could be made applicable. So what this amendment would do, it would prohibit or eliminate in the Standing Committee amendment the automatic right of intervention in a lawsuit. So I want to explain a little bit about what intervention is. Basically, the courts have rules which allow parties to intervene in a case, and it's covered under Rule 24. And this is an attempt for parties who might be affected by a lawsuit, who aren't a named party as a plaintiff or a defendant, to participate. So what they do is they'll usually hire an attorney if they're not one themselves. They'll file something called a motion, which is more or less an application to participate in that lawsuit, and they have to provide some information. They'll talk about their interest in the case, explain why the lawsuit could affect their ability to protect that interest, and they also have to demonstrate that no other party can represent that interest. So if the court sees that an applicant makes all of those showings, they can say, yep, this person has an automatic right of intervention in this case. We'll let them in. Courts also have another tool called permissive intervention. Here, the courts have a little more latitude. They can look at these applications or motions, look at the interest presented, and it can also say, you know, this party has a unique circumstance, unique information that would be valuable in deciding this case. We'll let them in under Rule 24B. So these are the tools available to anyone in the public. Anyone in Wyoming can look at a lawsuit and say, I'm going to file a motion, I want to participate in this lawsuit. My concern with this amendment, Mr. Chairman, is one of favoritism. Imagine that we were to pass a law saying the speed limit in a school zone is 20 miles an hour. Unless you're a member of the legislature, then it's 30. Imagine if we were to pass a crime saying you can't cause any bodily injury to a peace officer. If you do, you'll be in prison for up to 10 years. Unless you're a legislator, how about only 1 year for us? Those are special laws. We're creating carve-outs for ourselves that aren't available to anyone else in the public. So my concern with the language that we see in the Standing Committee amendment is just exactly that. A member or the members of the legislature, only those who sponsored or co-sponsored this act, shall have standing to defend this act as an intervention in any lawsuit. Folks, that's special legislation. We need to not be doing that kind of thing. And so what this amendment would do would simply strike that. And, certainly I want to be clear. I have no problem if any of these individuals, these legislators, want to intervene in a lawsuit. It's a matter of playing by the rules. If they want to intervene in this lawsuit, they should hire an attorney if they're not attorneys themselves, file the proper motion, make the proper arguments, and let the court decide. But for us to create a special carve-out or special rules for certain legislators is simply improper. It violates our Constitution. So with that, I'd ask you to support the amendment.
Thank you, Senator Ellis. We are on the Committee of the Whole Amendment Number 1 to House Bill 152. Back to you, Senator Steinmetz.
Thank you, Mr. Chairman. And this is a simple policy decision for the legislature. In 14.2.802, we have standing to maintain a proceeding in which we've given parents standing. In 17.16.741, we've given standing to corporations, partnerships, and associations. In 17.22.107, there's capacity to assert and defend standing. And so we have addressed in 34.1.2a 531, standing to sue third parties for injury to goods. So we have addressed this in other areas of statute, maybe not specifically to the legislature. As I've said, we looked around and there are other states that have actually addressed standing, Mr. Chairman. So I think it's a policy decision for this body, and I think the good bringer of the amendment, I really appreciate that she came to me with the amendment before she filed it, and we can have a good discussion on this area of policy. Thank you, Mr. Chairman.
Further discussion on Committee of the Whole Amendment, Senator Steinmetz? Excuse me, Senator Nethercott.
Thank you, Mr. Chairman. On and for the amendment, I want to thank the sponsor of the amendment for bringing it forward. The good senator from Laramie County is absolutely correct that it is special legislation to carve out not just the legislature, but only the sponsors of the bill who are dictating to the court that they actually have legal standing to participate and sue in the lawsuit. Why don't we just say it is constitutional? In fact, we've written this bill so well, this law so well, it can't be challenged in court, and no one else has standing. What would be wrong with that? I mean, we talk about standing in statutes. Why couldn't we say who hasn't? Who does not have standing? Can we do that? No, that would be special legislation. That would be unconstitutional. The good senator from Laramie County is trying to improve this bill, which has some legal challenges in it, and this is one of those ways. The other areas where standing is mentioned in our statute really relates to when someone actually has a legitimate justicial controversy before the court, and they may be affected by that. The good senator mentioned Title 14 with juveniles. Yes, if your child gets taken into state's custody, the state of Wyoming has said that as a parent, you can have a right to participate in that legal proceeding concerning the welfare of your child. So yes, there are certain exceptions to where we have afforded standing, but it makes good sense because there's a direct justicial controversy concerning the party to that litigation. We don't pre-select who those parents are. We don't pre-select which those corporations are. And so I want to urge support of this amendment in order to be consistent with the Constitution and the laws of this state. On and for the amendment.
Further discussion on Committee of the Whole Amendment, Senator Dockstader.
Thank you, Mr. Chairman. Just for clarification, though, what I heard in that whole list that was read, that we have precedent-setting situation. So we're probably already there. For those who chase the legal world, I heard that we have precedent-setting situations already out there. So I'd probably be against the amendment.
Let's go to Senator Rothfuss. Then we'll come back to Senator Nethercott, then to Senator Ellis. Okay.
Thank you, Mr. Chairman. I don't think the statutory provisions provide true precedent. I think there's a substantial difference, because if you take the bill draft you have and go to the front page, that's literally the list of people that have standing if this bill passes. That's a little different from saying, when we're talking about certain corporate considerations, these types of corporate structures, individuals related to them will have standing. Or when we're talking about Department of Family Services, parents will have standing in certain circumstances. This is a different level when you actually have a list of the names, Mr. Chairman. We all can read through the names, and that is the complete list. That list isn't going to be amended. It won't change with time. It's literally the names on the front that would have standing. So as far as special legislation is concerned, that certainly qualifies. I do think there's another area, though, where I appreciate the thoughtfulness of this amendment with regard to its unconstitutionality, which is really getting into the separation of branches of government in addition to just the specific legislation. It's the idea that the legislative branch would dictate to the judicial branch what their procedures will be. This is a great place for us collectively to stay out of, realistically. This is where we want to be deferential to the courts. And what I think it's come down to, Mr. Chairman, is that we didn't like decisions by the courts with regard to their procedures and practices, and so we want to write the names of certain individuals onto the docket. Again, the idea that we can extrapolate from existing statute to this level of specificity, I think, is a significant stretch. It is not consistent with previous precedent. It would be a bad practice for us to go down. And Mr. Chairman, I want everyone to, think through other scenarios about if we can go here, really where can't we go? That was the point of the good senator from here in Laramie County that spoke a couple of minutes ago, in the idea that why not just write the outcome of the decision itself if we're going into the realm of the courts and the judicial branch? Well, there's good reason for that. We support separation of our branches, separation of powers, and this is certainly an invasion of that. So on and for this amendment. It's very thoughtful.
Senator Nethercott? Okay, let's go to Senator Case and then back to Senator Ellis.
Thank you very much, Mr. Chairman. I'm also in support of this amendment, and I want us to think about it for 1 second in terms of we don't really exist as a policy entity as individuals. You all have the force of your office, and we can write letters and things, but we don't have any specialness about us. We exist when we're here together, creating and acting as a legislative body to create the body of laws, to override vetoes, and to do things as the Senate and as the House and as the legislature. We don't exist as Senator Jones or Senator, I didn't mean to use a proper name. I just picked a common name and I apologize, but Senator Chairman up there.
We'll overlook that, Senator. Go ahead. Thank you.
If this were to happen, then our members chosen would now have a policy role outside of the legislature, and they could go into court and carry forth policy decisions about that litigation. That's a grant of authority we can't give and we don't own to give because we only exist as us. On and for the amendment.
Senator Ellis.
Thank you, Mr. Chairman. I want to talk a little bit about the distinction between standing and intervention. Standing is an important concept in our legal system. You have to be injured by certain action in order to prove that you've been harmed by the government. So when you file your lawsuit, you tell the government, I have standing, I was hurt, here's my story. And so this is a limit on our courts, so they can't just look at our statutes and say, in a vacuum, we don't like this one, we think this has problems, we don't like this. They need a case or controversy. And so standing is an important concept in our courts for them to really focus solely on what's before them. That's standing, and that's something that anyone who files a lawsuit has to show. This is different. Intervention could say, wow, look at that case, that actually affects me too. It's a way that courts can bring parties together and try and resolve issues in a really thoughtful way and bring in the parties that make sense. So to take it out of the context of this example, in our national environmental laws, Congress has passed laws that say any person who thinks that an environmental action might be hurting their enjoyment of where they live, they have standing. They can bring a suit. So they do. Sometimes environmental organizations bring those. And they'll file a federal agency and say, by them granting that grazing permit, they're diminishing my enjoyment of the environment. So the lawsuit's between the environmental person and the federal agency. Wyoming can look at that and say, wow, if that affects a grazing lease or an energy lease, that affects our revenue. Hey, courts, we have an interest, we want to intervene. So what the state of Wyoming does routinely, files a motion and says, here are our interests. Here's why if you, court, look at this issue, you need to hear our voice too. It's about making sense and making this work. So I want to clarify, standing is different than intervention. Intervention, all I'm saying is you have to apply through a motion to the court explaining your interest. That's what you have to do. That's what any citizen in Wyoming right now can do in any lawsuit that's brought related to this act. Anyone can do that. My objection isn't even for the people named as the co-sponsors to do that. They should go through the application process, file their motion to the court, make their case. That's appropriate. My problem, senators and colleagues, is this lets them skip that whole process. Somehow their interests are more important than anybody else's in Wyoming. Not just even the 31 members sitting in here or the 62 down the hall. Only the people whose names are on that. So again, imagine if we did that in any other context. I want to apply for a hunting license. Oh, but those are hard to get. How about if, since I drafted this bill, I automatically get that license? That's essentially what we're doing. That is special legislation. Our Constitution prohibits that. So please vote for this amendment. Allow those individuals who care about this issue, and I appreciate that they do, play by the rules of everyone else. Let them file their motion and make their case to the court. On and for this amendment.
Thank you, Senator Ellis. We're on the Committee of the Whole Amendment, number 1 to House Bill 152. Further discussion? Is there any further discussion? All those in favor of Senator Ellis's motion on the Committee of the Whole Amendment, number 1 to House Bill 152, please say aye. Aye. Any opposed, no. Committee of the Whole Amendment, number 1 to House Bill 152 has passed. We are back on the bill. Further discussion on House Bill 152. All those, Senator Scott.
Mr. Chairman. Mr. Chairman, those of you in the Senate have heard me on this subject before. But let me say, this is a very serious bill, very serious issue. There is, Mr. Chairman, in our society, a great division on this subject that is largely based on the religious beliefs of the individuals in the society. Mr. Chairman, there are many that believe that human life, a new human person, starts at conception and should be treated as such at that point. That's the point of view in this bill, Mr. Chairman. There are those who do not believe that. Mr. Chairman, we've had a similar issue that's in our statutes, and what it did was over the funding of abortions. And we put that in statute, and I was one of the ones involved. I think I'm the only member that can say that at this point, because it was done so long ago. We put that in the statute because we felt that the people, the churches, the religious beliefs, that abortion was morally wrong, deserved to be recognized and deserved not to have their tax money used to fund abortions. And that piece of legislation stood the test of time. Mr. Chairman, we've inquired and it has been quite effective. This is the other way around. This bill, the church I belong to, and a number of the other churches in this state, with quite a number of members, believe that it is, particularly in the early stages of pregnancy, it is the right of the woman involved to decide whether the pregnancy is going to go all the way to creating new human life, a new person. We believe that it is the right of the woman to decide, no, that's not an appropriate thing to do in this case. That's what our church believes. This bill says that acting on the beliefs of our church are criminal. Mr. Chairman, I submit to you that this bill crosses the line and imposes the will of one set of religions on those of us who are of a different persuasion. And that's not appropriate in a free society, Mr. Chairman. So I must speak against this bill. I must vote against this bill. I respect the opinions of the majority and have voted to respect the opinions of the majority. But I do not think they should be imposed on those of us who happen to be in a minority due to our religious faith, Mr. Chairman. So on and against the bill.
Are you ready for the question? All those in favor of Senator Rothfuss.
Thank you. Mr. Chairman, I know that nobody wants to debate this bill any longer. I got it. But, Mr. Chairman, at the end of the day, there's a lot of folks watching this debate right now around the state. They care a lot about this bill, and they don't necessarily agree with the cram down that's going to go through with this bill. That's the reality of it. The idea that a vast majority of this state strongly supports this bill is not accurate. Honestly, there's two significant viewpoints, differing viewpoints, both with strongly held beliefs, in conflict and contrast. I don't think we really have a good sense of exactly how many feel which way and what the nuances are. But, Mr. Chairman, it's certainly appropriate for us to take the time to debate an issue that is this important and that is, as I see it, Mr. Chairman, strongly detrimental to the individual rights and interests, certainly of the constituents that I represent. Mr. Chairman, the idea that we would once again aspire to pass legislation that is strongly aligned with a set of religious principles rather than constitutional provisions is troubling. Mr. Chairman, the initiation, the beginning of the concept of the freedoms of religion in this country, at the core and at the root of our freedoms, First Amendment rights, are not based on the idea of freedom to be one particular type of religion or freedom to practice the mainstream religious beliefs. They were premised and founded on the idea of the exceptions, of the differences, of embracing the idea that not all views are going to be the same. And there was this incredible debate and discussion about the separation, this great wall of separation between church and state, to recognize that we didn't have to fight based on religious beliefs. We didn't have to bring those beliefs into our politics, and that we could have those individual beliefs separately held and coexist, Mr. Chairman. This legislation flies in the face of that. This legislation, particularly the findings and purposes of this legislation, so we know what the findings and purposes of this legislation are. They're literally called out in the beginning, presuppose a set of beliefs that are consistent with some religious beliefs for the purpose of enshrining those religious beliefs into statute, into Wyoming statute, abandoning the idea that all religions should be treated equal, abandoning the principles of Article 1 of the Wyoming Constitution and saying, no, we're not going to do that anymore. There are some beliefs everyone must follow. Everyone in this state, if we've got a majority, constitutionality be damned, freedom, we can forget about that here. And we are going to adhere to strict religious beliefs of certain religions and certain sects. At the same time, though, Mr. Chairman, we know that Article 1, Section 38 of the Wyoming Constitution, right of health care access, is being denied by legislation that steps between a healthcare provider and their patient. In fact, criminalizes the provision of healthcare, not just stepping between and providing advice or guidance. Now, this chamber is looking at 10 years criminal penalty, 5 years criminal penalty and $20,000 in fine or both, loss of license, for engaging in medical procedures requested by a patient to their healthcare provider, consistent with common practices that have been universal in this country for decades, up until a recent Supreme Court decision. That right indicates that each competent adult shall have the right to make his or her own healthcare decisions. The parent, guardian, or legal representative of any other natural person shall have the right to make healthcare decisions for that person. And the D paragraph, the state of Wyoming shall act to preserve these rights from undue governmental infringement. Well, when we have infringement, Mr. Chairman, that goes into our U.S. constitutional First Amendment rights of freedom of religion, picks a side, picks a belief system, forces that through the findings upon all citizens of the state of Wyoming, and then in the name of that religious doctrine infringes upon Article 1, Section 38, it seems that the legislature is not taking steps to protect that right. So, Mr. Chairman, I understand that this is politically heated, politically contentious. I understand that it's divisive. But, Mr. Chairman, I have no interest, I'll say it again, I have no interest in changing anyone's mind or changing anyone's approach or changing anyone's belief or actions with regard to this topic. I don't want to convince anyone in the state of Wyoming to defy their strongly held beliefs, however they arrived at them, whatever they're based on, whatever the foundation is, be it their religion, philosophy, or anything else. Mr. Chairman, this does the opposite, regrettably. This says there's a winner. There's one belief system that is acceptable. And I'd encourage the chamber, although I understand that many of you have made up your minds, but perhaps one last time, think if this were coming from the other direction. And rather than facing a bill that restricts religious freedom in this capacity, it restricts it in another capacity. And it was being forced down upon each of you. So not offered as free choice, but if the counter viewpoint were actually being enforced upon each member of this chamber, so that you had to accept the pro-choice viewpoint as a requirement, that would be a true infringement upon your individual freedom of religion, just as this is a true infringement upon about half the state's belief, religious freedom, and desire for separation of church and state, Mr. Chairman. On and against the bill.
Let's go to Senator Boner, and then Senator Case and Senator Nethercott.
Hey, thank you, Mr. Chairman. For better or for worse, I don't have to mention what it's like to have a policy decision I disagree with forced upon me. That's been the case for almost 50 years. When the United States Supreme Court stepped down and had this ruling that has recently been overturned. So I know exactly what that's like. We know what that's like. I submit to you that the division, the challenges that we have in our state and our country are due to that. Very poor judgment by a group of 9 people back in the 70s. Because we haven't had a chance to discuss this in any meaningful way. We haven't had a chance to really get some feedback from our constituents. I point out, Mr. Chairman, that we have had an election since the time of that decision and the time we're sitting here now. So this is what we do. It's a difficult discussion, I understand, but now it's time to make these decisions and continue to make these decisions. I point out that in other Western countries, where they didn't have to deal with the legal precedent we had for half a century, this issue isn't nearly as contentious because they've had the opportunity to come to some sort of agreement using their elected officials. So that's exactly what we're doing. Now, Mr. Chairman, we've heard a lot about religion. I point out that the opponents of this bill are the only ones that I've heard discuss religion on this floor. Personally, I'm convinced by the fact that at conception, you have your entire genetic code set. That to me is the most logical point of when life begins. That's what I'm basing my decision on today. And so I hope that we can continue to have this good discussion. I think it's long overdue. I know it's tough. I know we're not used to having it, but it is important that we continue to have this discussion after we've had input from our constituents, and now that we know exactly where the United States Supreme Court stands on this issue, and now we have the opportunity to find out where our state stands. So on for the bill.
Thank you, Senator Bonner. Just a quick comment from the chair. I just want everyone to know that we are not in a hurry. This is an important bill. It's House Bill 152. When nobody was standing, I anticipated that maybe we were ready for the question. I'm not in a hurry. Senator Case.
Thank you very much, Mr. Chairman. Appreciate it. It's sometimes hard to see around the room from that chair, and appreciate what you're doing. So I'm trying to figure out what this bill accomplishes now in its amended form that's any significant change for all of you that are advocating it over the bill that's currently being litigated. I think there was great hope that we would have a bill that said, hey, look, court, the legislature gets to interpret the Constitution too. Muscle up, get out of the way. That's not in the bill. It's gone. There was a notion that some people weren't allowed to intervene, and it was felt that that would have been, the intervention was denied. That was felt that that was maybe a disadvantage. So this bill tried to say, you're going to let these people in to defend what we're telling you in the existing case or in future cases. That's not in the bill anymore, Mr. Chairman. You follow me on this? It's not a trigger bill anymore, Mr. Chairman. There was this thinking that, all right, we've got our trenches out there in the front row, and we're fighting the court, but if we lose that fight, we've got this new line of defense right here. That's not in this bill anymore, Mr. Chairman. That's out. So what does this bill accomplish that the other bill that we passed out of here that's now in the courts does? And do you, Mr. Chairman, do you believe that this one wouldn't go to court in the same manner and maybe be interpreted and ruled on in light of the other court? Because neither one of these undoes the constitutional deal about the right of health care that is in the court. You know, and you can say in here that abortion is not health care, but that's what we're litigating. So I'm just asking you, Mr. Chairman, what does this bill do that's different than what we have in the Wyoming courts now? I submit to you it's not a change. It's just making a lot of people feel good, feel that they're in the fight, and I get it. This is so basically important and in your heart. But I got a lot of people at home that feel the other way. And I'm from a district that, I think I told you the story last year, that I have 2 coffee shops in town. One's kind of where the progressives go, and one is run by a religious college in town. They both have great coffee. Let me just be very clear about that, and I like the coffee in both places. But there is a very different feeling there. And I have a feeling, Mr. Chairman, that this is one of these issues that our increasingly dominant major party being governed by fewer and fewer people without allowing for expression from other members of that party has brought us to this point. And this is out of sync Mr. Chairman, as other things are, with the populace of Wyoming. And when it comes to that, you know, I'm not sure, we have a court case that's going to be of great magnitude. It's going to be decided one way or the other. I don't know how it's going to be decided. We have a unique Supreme Court with more women than they've ever had. And when it gets there, I'm going to be interested in what they think about this. But Mr. Chairman, I don't think that they would rule differently on this bill, this law, than they would have on the one that's moving that way. What are we accomplishing here other than I seem to think that I'm making everybody at those two coffee shops home angry? The progressive coffee shop's mad at me for different reasons, but anyway, Mr. Chairman, I want to get out of this mess. I think we should not pass this because it doesn't do anything more than what we've already passed.
Thank you, Senator Case. Senator Nethercott.
Thank you, Mr.
We'll go
Chair.
to Senator Salazar.
Thank you, Mr. Chairman. Really great speeches. I really want to get to the heart of the bill. So we have outlawed abortion in our state. We are on track to continue to do that and to continue to really lock that down. Now we need to work these bills rather than just discuss good and evil, religion not evil, right, wrong, pro-life, pro-choice. Just disregard it all, okay? Now we have real people in Wyoming who are affected by this legislation. Does it work? And those real people are pregnant women and their medical providers. And so a question that I have and mentioned to the sponsor, or the floor sponsor of this bill, the interveners, which is, how does the law handle a severely disabled baby? That's what we're calling it now by law. So let's say, for example, we have a mother of 4 who is thrilled about her new pregnancy and this new child that they're bringing into the world. And then she determines in her prenatal care visit that at about 18 weeks along, the baby has no frontal lobes of its brain. It just has a brainstem. It is alive. It has a heart that is beating. It has hands and toes and a partial skull and a partial face, and it will continue to grow, and she will bring it to term. It has no frontal lobe, neither. There'll be no frontal brain development. What does she do? What does the doctor do about that? If she delivers at full term, more likely than not, the child will live for an hour, maybe 20 hours, maybe. But it will not survive. Is she allowed a procedure to handle that situation? It is a life, right? We have determined that an unborn baby begins, and that definition of an unborn baby is fertilization, and abortions are not lawful. So in severe birth defects, and that scenario maybe you feel differently about from a religious perspective or others, but there are other types of very severe birth defects. There is a baby inside, there's a zygote that's been fertilized, right? There's a fertilized embryo that's growing. It will never be viable. There's a severe birth defect. Now, there is a provision in here that says reasonably medically necessary in the good judgment of the doctor. Now, if the good judgment of the interveners determines that that good judgment was incorrect, that's a felony, right? Those are criminal punishments. Those are civil penalties. These are really big decisions. And so I'm really asking you truly what medical providers are going to take that liability or take that risk. And what are we doing to families who are faced with these circumstances, who are tragically not wanting to be in there? So I really need us to think very carefully about this and these unfortunate circumstances that Wyoming families and medical providers are in. with a pro-life approach, okay? I need you to have your pro-life hats on. I know you are, but really to understand those circumstances that we maybe are not addressing as thoughtfully as we can. And the harm is there's women pregnant right now who will be facing what are very common and severe birth defects for their children. So just conversations about that.
Senator Salazar.
Thank you, Mr. Chairman. Obviously, I'm in favor of this bill, but I want to talk specifically about a different issue. The issue was raised about religious faith in this issue. And let me say, first of all, that I honor and respect the Chairman of Education. I honor and respect the Minority Leader. They're both my friends. I respect them. But throughout the 2 years that I brought my brought my bill on this issue, I don't think that I ever talked about religious faith. I've never advertised my religious faith. I don't think it's anyone's business what my religious faith is. I had a reporter last week say, "What's your religious faith?" Well, it's none of your business what my religious faith is. This is, to those of you who come about this issue from your religious faith, that's fine, that's great. But there is also a secular community in this country, and you can still be in favor of this type of legislation. Our founding fathers believed strongly in the separation of church and state. And I don't think that you have to be secular to protect secular rights. So the issue that this is a forced issue by those of the religious community to impose on another community, I don't think is correct. I don't think you have to be part of the faith community to support legislation like this. And I'm hoping that eventually, as this topic continues to be discussed and debated in states, because now it's been thrown to the state legislatures because of the Supreme Court decision, that we can move away from religious issues and talk of the issue on its merits of whether you believe life begins at conception or not. And my point is, you don't have to come from a religious perspective to support such legislation.
Thank you, Senator Salazar. We're on House Bill 152. Senator Hicks.
Yeah, Mr. Chairman, so I hear my colleague from Laramie County here, but the question I have is so where do we enumerate all these unforeseen circumstances? How do you go about enumerating each one of these circumstances, as she described, that may occur within the bill? So that would be, it's a legitimate question. If that's a concern, then how do we enumerate that? Where would we do that? So that's one question, Mr. Chairman. So, it comes down to it, and we can debate a lot of these different issues. The simple fact is from my perspective, we were founded as a Christian nation. We're a Christian nation. Our history's true. Now, there is a tremendous number of different sects. My colleague over there, I'm guessing, probably thinks that his church is a Christian sect amongst the many sects out there, Mr. Chairman. With respect to the separation of church and state, this is not about church and state, folks. That debate doesn't even come in. In fact, you can't find anything in the Constitution about church and state. What this is about your fundamental beliefs, whether there is a supreme being, God, for the lack of a better description, and the laws of God, that whether we violate those or not. It's not about whether I'm a Baptist or a Protestant or a Unitarian or a Scientologist or whatever religion I profess to be. That's not what this is about. This is not about a church and state issue. It's about our fundamental beliefs as whether there's a supreme being that is endowed in us the creation of life. And so, Mr. Chairman, as I sit through and I listen to this debate, the question I have to ask myself, if I don't believe in procreation, and I'm an evolutionist, how do we get to the point where we have a primordial soup out there 6 billion years ago? And in this primordial soup, we just have to have the right chemical makeup that creates these amino acids. And once these amino acids combine, that becomes life. And that spawned all life on Earth. How is that life any different between two amino acids than a primordial spook that combine and create life? How is that any different than two zygotes, two human cells merging to create life, Mr. Chairman? And quite frankly, I have a hard time saying I can believe in evolutionaryism with amino acids spawning life, but I can't believe in two human cells, two zygotes that combine and become one, and that's not life. So, Mr. Chairman, this is a very serious debate, and we're going to come through it from different perspectives. But, you know, the good minority floor leader said, this is wrong because this is happening and the supermajority is enforcing this on the, Mr. Chairman, this same debate is going on to other states, and yet the counterparty is exactly the same thing going on, where you have a very small minority of one group, one political affiliation, that's being dominated by another political affiliation, and the reverse is happening. That's the beauty of our system, Mr. President. We have 50 states. We have 50 different laws. This is the way the Constitution was crafted under the Bill of Rights, that each state is going to make this decision. It's not shoving our beliefs down the leaf of everybody in the United States. It's representing the values that we think as our constituents. I was democratically elected through an electoral process to come down here and represent them. And if I don't do that, Mr. Chairman, they'll send me home, and rightfully so. So when we get into this debate that the supermajority is somehow doing some level of tyranny on the minority here, I would fundamentally disagree, because that violates our very principles of an elected form of government. I also know the very same thing, that the debate that we're having here, the reverse is occurring in a number of states in the United States, as it should, under the Supreme Court ruling, Mr. Chairman. So again, that's my overall concern, but I am really concerned about how we enumerate every instance within this legislation to address the issue my colleague brought forward.
Let's go to Senator Nethercott, and then we'll go to Senator Kinski.
Mr. Chairman, thank you. And again, I know
Senator Hutchings, I'll come to you in just a minute. If that was why we were waving, I'm just trying to understand what exactly that was in the middle of the debate. So let's allow Senator Nethercott, and we'll get to you, Senator Hutchings. Go ahead, Senator Nethercott.
Thank you, Mr. Chairman. Senators, again, I urge you with your pro-life positions in full focus. We are now at that juncture where we're not debating pro-life or not. That decision has been made by this Wyoming legislature. So I need you to reorient to what we're doing, please. And the pregnant women and the maternal aged women of this state really appreciate the debate, but they're in a situation and they need help, all right? So where should that go? The majority floor leader asks, as if it's too hard for us to figure out. Probably in the definition of abortion or what abortion is not. So if we can go to that, please, on page 5, because we got to start working this. These are medical procedures that will be legislated, all right? So page 5, line 16. Abortion shall not include any use, prescription, or means specified in this paragraph if the use, prescription, or means are done with the intent to. So these are the exceptions to what abortion means. There are 3 of them. To save the life or preserve the health of the unborn baby. What's notable here is, does it say to save the life of the mother? I don't know if that's an oversight or not, but it appears to be only the life of the unborn child, of the baby, okay? So the life of the mother is irrelevant, and you can't get an abortion if the mother's life may be in jeopardy, okay? If I'm wrong about that, please, let's debate what the bills say and get this figured out. Moving on to page 6, lines 1 and 2, you can do an abortion to remove a dead unborn baby only if it's caused by a spontaneous abortion or intrauterine fetal demise, which I would suggest to you that, I mean, by virtue of the baby being dead, it may not be an abortion, but maybe it is under a medical procedure as defined by abortion. So if the baby's dead, you can have a procedure to remove it. Or to treat a woman for an ectopic pregnancy, which obviously means that it's never going to come to viability. Those are the three exceptions to when an abortion can be administered. That's it. So if we were to understand those circumstances where severe birth defects or medical necessity associated with that severe birth defect need to come in, this would be where that would go. And I do think we need to carefully consider that as an option. It's important to recognize, at least in my interpretation of this bill draft, that if we go to page 6, lines 12 through 16, we have reasonable medical judgment, but that is not an exception to abortion. That is just a definition of what reasonable medical judgment means. And so you can exercise reasonable medical judgment, a doctor can, but that does not authorize the use of a procedure, an abortion procedure, under any circumstance unless the baby's already dead, or the baby will die, or it's an ectopic pregnancy. So just for some clarification on those pieces, because those are the details we really need to understand our constituents care about now, and the healthcare providers do as well. So some additional conversation about that. And then just another piece, because I don't know, but people will ask me, we are extending this definition of a baby to fertilization. So a baby is a fertilized egg. And so are there any drugs that are given, like the morning after pill, those types of things, are those now an abortion and unlawful because we have determined fertilization? A question about that.
Senator Kinski.
Thank you. What about Senator Nethercutt, or Senator Hutchings?
I had you up before,
Okay.
Senator Hutchings, Senator Kinski, and then
thank you.
I'll be happy to go to Senator Hutchings if she stands to be recognized.
I'll defer to her.
Okay. Senator Hutchings?
Find answers to some of the questions. Go ahead.
I fit on and for the bill.
Senator Kinski, go ahead.
Thank you, Mr. Chairman. On and for the bill. I'm pro-life. I agree with my colleague from Laramie County. We do have an obligation to make sure the bill is well-written. And I had read it in its first form and had passed along to one of the sponsors that I thought it was a little bit awkward that on page 6, we define abortion and then define what a portion shall not include. And then on page 8, we say there's exceptions to the abortion, whether it's an abortion or not. So we have exceptions to the definitions and then exceptions to the crime, which is really awkward. I mean, it should be in one place or the other. And this is just not just a nicety. I mean, you want to make sure that this thing is clear. So that's the first one. Second, I've taken this stuff seriously enough that I've spoken with my deacon about it and what he's learned in terms of, I will say, morals class and within the context of our faith, and when is it wrong, and when can you not say it's wrong? So an ectopic pregnancy, I didn't know what that was, but that's when the egg gets caught in the tube and it is going to grow. It is going to grow. And it will eventually burst. And I said, and then the woman will bleed out. I never understood that. So I talked to 2 OBGYNs and the director of our medical group. And they explained it to me, you know, when that baby is in there, even if it's in the tube, it hooks into the mother's blood system. And when that explodes in an ectopic pregnancy, they will bleed out. You have to get in there and remove those tubes, remove that pregnancy in that tube. And my understanding is there, you cannot make a moral judgment that taking that fetus is wrong because you have to save the life of the mother. So there is an exception for an ectopic pregnancy. But as with my colleague from Laramie County, when I listen to these medical professionals, I realized how lucky my wife and I have been. We just had 3 babies and they were healthy. But when they described to me fatal fetal anomalies, a child without a brainstem, or a child that's forming lungs but has no ribs. So it'll be born, it'll be dead within a matter of minutes. Is it right to force the woman to carry that baby to term? Is it wrong to intervene at that point? I'm not sure that it is. I think we have an obligation here to deal with the nuances that really do apply to these situations. We've got an ectopic pregnancy in there. We need to, and my colleague from Carbon County said, can we enumerate all of those? I think we ought to try. I think we ought to take an honest effort to say, these are the situations where this, you can't put a doctor where they're a fear of going to prison when they know this is just not a good situation. And I am avidly pro-life, but I had no idea how many things can go wrong in a pregnancy, none. And so we've dealt with ectopic pregnancy. I would ask the sponsors to give some consideration to dealing with some of these other situations and perhaps drafting it so we're not talking about exceptions to the exceptions and trying to figure out what is or is not a crime or what is or is not an abortion. Thank you, Mr. Chairman.
Thank you, Senator Kinski. Further discussion. Senator Hutchings.
Thank you, Mr. Chair. Didn't mean to be rude, but I did stand up several times and wasn't recognized and frustrated. When I read the topic of the bill, Mr. Chair, it says it's life. Life is a human right. And when I signed on to the bill, I was told that it was trying to answer issues that came about with the lawsuit from the last bill that we brought forward. So I think that's what they're trying to do here, is answer a lot of those issues. And I believe that if we need to, we can always amend what we have. We can fix it. And we've done that before, and I know we'll do it again. For me, this is not a matter of religion. It's a matter of life. And I think as a nation and as a people, we're doomed if we do not try to do what our Declaration of Independence said we're supposed to do, and that is secure life. Our Wyoming Constitution in Article 1, Section 2 talks about the equality of all in their inherent right to life. That's Article 1, Section 2. And Article 1, Section 6, it talks about due process of law. No person shall be deprived of life. So for me, this is all about life. I'm not an eloquent speaker like the previous speakers, and I don't want to change the narrative of what the bill is trying to do, and that is to secure life, Mr. Chairman, and that is what I wish we would stick with. I know there are a lot of definitions in here. We have in Article 30, or in Title 35, 6101, it defines abortion. And again, if we can amend this bill to make it something everybody can pass, I think that's a good deal. And I thank you for the opportunity to speak, Mr. Chair. Finally.
Further discussion on House Bill 152. Senator Cooper.
Thank you, Mr. Chairman. Quite a debate. I've got about 4 little things that are bothering me real bad. One of them, I'm really wondering if this is constitutional. And obviously, based on the debate we had earlier on our amendments, even some of the bringers of this bill wonder if it's constitutional because we all think it is going to end up in court. We've got a bill right now that does what we're trying to do here, I believe, and it's in court. So are we stepping out too fast and trying to fix something that we don't know is broke yet? Secondly, we heard argument that this is not one religion over another. My personal belief, my personal religious beliefs tell me that life begins at fertilization. But I can't ethically tell another senator or another senator that that's what they have to believe religiously. That's wrong. I've got a lot of emails, you all have too, and after you do the swiping from all the ones that aren't yours, my constituents are pretty evenly split on this. This is too important to get wrong. It's too important to get wrong. I'm going to leave it at that, but constitutionality, ethics, constituents, those are my issues today. Thank you.
Okay, further discussion on House Bill 152. Go back to the floor sponsor, Senator Steinmetz.
Thank you, Mr. Chairman, and thank you all for the good debate on this bill. And the question I would ask is, how can you have freedom if you don't have life? And so our Constitution in Article 1, Section 2 says equality of all and their inherent right to life, liberty, and the pursuit of happiness, all members of the human race are equal. And with regard to fetal abnormalities, those are always hard questions for doctors, for patients, for everyone involved. And, you know, there's a lot of emotional distress. There's ethical principles that doctors have to adhere to. There's duties of obstetricians to provide emotional support and to make those decisions with their client and with the mothers and families after viability and dealing with this. And there's other ethical decisions that have to be made. So if there's some ideas and thoughts that we need to consider that haven't been considered, that's what we're here to do. As far as lethal fetal abnormalities, I have some personal experience with this. When my daughter was pregnant with my grandson, they came to her and said, you need to abort him because he's too deformed to survive. He's got Down syndrome. He's incredibly deformed, and you really have got to abort this child. And her whole pregnancy, they came to us with that. And when we got down to the very end, he was having heart distress, and so she never agreed to an abortion. And we went down to the NICU in Denver, and excuse me for using that proper name, Mr. Chairman, I apologize. And he was born, and he has Down syndrome, but he was not horribly deformed, and he is a wonderful little man, and I'm so thankful that he's in our life. So sometimes we don't always know. We don't always know until they're born exactly what we have. And we can try to predict that, but we can't always do that. As wonderful as medicine is, and it is so wonderful that it saved his life, and he was in the NICU for a month and a half, and we were able to bring him home after all the tubes and feeding tubes were removed. And so, Mr. Chairman, we don't always get it right, and many times mothers are distressed, but they need to, they want to save their baby, and I think that's the difference with this is the intent. Are we voluntarily ending a life because we do not want that child, or are we really trying to save two patients? And that's the difference between healthcare and abortion. In healthcare, we're trying to care for 2 patients and save 2 patients and see 2 patients living healthy and alive. And in abortion, we're trying to end the life of 1 patient. And so I think that this bill goes a long way in defining that. If there's further work to be done, I'd be glad to work with those who are bringing up good issues on this good bill. And with that, Mr. Chairman, I hope I've answered some questions. I'm open to visiting with my colleagues, and I appreciate the good debate on this bill.
Thank you, Senator Steinmetz. Senator Nethercott.
Thank you, Mr. Chairman. Just for clarity, I have a series of questions that the public needs to know. Otherwise, any amendment will be seen as something that it isn't. Is it the policy of the sponsors to allow for an abortion if the life of the mother is threatened? 1. Is it the policy of the sponsors to allow for an abortion in the case of a severe fetal defect? Those are my primary questions, because I just need to know if this is going to be a very difficult amendment, or work on the bill, and I just need to know if it's what the intent of the sponsors are, both for the people of Wyoming and for our time here within this legislature.
Senator Brennan.
Thank you, Mr. Chairman. Excuse me. A couple of good questions, great questions have been brought up with this bill. First of all, the life of the mother. If the life of the mother is endangered, we often hear that argument, but what we don't often consider in that argument is the mother is what keeps the baby alive. And if the mother doesn't have life, the baby doesn't have life. And so you really have to save the mother in order to save the baby. There's 2 patients, but the mom is what is providing that life to the baby. So while that is a good debate, I think that we often forget that we have to have life for the mother to have life for the baby. As far as fetal can't talk today, fetal abnormalities, that's a really good question. And that falls in this gray area. And that's something that is hard to grapple with. I've seen a lot of birth come in lives, a lot of babies be born. I've seen a lot of birth in my lifetime, in my career. And I've seen a lot of death in that time. As somebody who's worked in those areas in healthcare. And that's a hard one. It's a hard one to grapple with, but I think it's something that we can take a look at, because that's not an easy one it's not an easy one for the legislature. It's not an easy one for physicians, for healthcare providers, for families. Those things bring about grief, and grief is never easy. So just some thoughts and perspectives on those 2 things.
Senator Rothfuss.
Thanks, Mr. Chairman. I do think that those things, the topics that we just heard, bring about grief and are very difficult, incredibly difficult decisions when a mother and a father and the family have to face those types of decisions. Prior to the Dobbs decision, the Supreme Court decision that overturned Roe versus Wade, that struggle was a struggle for the parents and for the family. It was an individual right. Mr. Chairman, it still is, actually, because the Dobbs decision didn't change that. The action and the effect of the Dobbs decision was to allow a state legislature to step in and make that decision instead of the individual. To override an individual right, to override that hardship, that choice, those circumstances, the medical decision, the grief, battling through that, where that would be done, again, by the mother, the father, the family, based on the circumstance, and their health care provider, consistent with the Wyoming Constitution, and say, no, Mr. Chairman, the Wyoming legislature wants to make that decision for you. I appreciate the good senator from Sheridan pointing out that the first person he talked to explore this circumstance was his deacon, and that he followed up talking with healthcare professionals to find out the details. I think that's poignant in this debate, because the answers that would be received, the philosophy, the support, is going to come from the community that you live in, the beliefs that you have, and whether those are religious beliefs or philosophy, personal concepts and motivations, whatever brought you to that point, right now it's an individual freedom. And the culmination of those life circumstances that lead to the belief in the context of the circumstance that an individual is in provides them and entitles them to the opportunity to make those decisions based on those beliefs. This bill just tries to take another step, a little step further, to say the government knows best. This government knows best. And Mr. Chairman, the idea that these debates are going on in other chambers around the country doing exactly the opposite, that's not accurate. Those other chambers are simply continuing to respect the fact that it's an individual right and freedom, not passing legislation. There's no debate that needs to be done to allow an individual to maintain her rights. You don't need additional debate to not take away her rights. No, it's a legislative act to strip away her rights. We passed some legislation that's currently being looked at by the courts. This bill tries to take it a little step further, tried to take it a lot further. There's some amendments that scaled that back. Again, Mr. Chairman, the idea that big government is the solution here to those problems of grief that we heard described, that we know best, the members of this chamber know better than that individual mother struggling with the grief. Oh, that's a big step. I'm against.
Further discussion. Senator Hicks.
Yeah, Madam Chairman, it's interesting this discussion comes. Mr. Chairman.
I
I'm
beg
so
your
used
pardon?
to dealing with Madam Chairman in my committee, I apologize, Mr. Chairman.
Yeah, I'm sure that was it. Go ahead, Senator
My
Hicks.
apologies. So the idea that government's doing this is, first we have to ask what the very fundamental nature of the responsibility of government is, Mr. Chairman. What is the number one responsibility of government? Our government. It's outlined in our Declaration, our Constitution. Number one responsibility of government is to protect your God-given rights. That is government's responsibility, Mr. Chairman, and that's what we're talking about here, the right to life. And it is appropriate that we should have this debate. It is appropriate that government should defend that God-given right to life. That is our primary, number one responsibility, is to protect those rights, Mr. Chairman. Now, me and my colleague, the minority floor leader, may disagree on that. But the way I read everything, and our history and our documents and everything else, that's exactly what government's supposed to do, Mr. Chairman.
Senator Ide.
Thank you, Mr. Chairman. Just want to echo those comments. I've been sitting back listening to all of this. I'm a sponsor on the bill, and I heard the comment on big government, and Senator behind me got up before I could. He hit the nail on the head. That's what I'm here for as well. We're here to protect life, liberty, and property. And that's what this bill does. The number one thing, it was mentioned before, it's in our Declaration of Independence. When I campaigned, people asked me where I stood on this, and I said the Declaration of Independence, that's the first thing that it says in there is to protect life. Thank you, Mr. Chairman.
Senator Dockstader.
Thank you, Mr. Chairman. I don't need a religion to tell me to stand for life. It's my own basic belief and concept. I don't need to be mocked if I choose to do that. It's not about ball caps, or buttons, or anything. It's just simply that's where I stand. And if there's concern that maybe this state is shifting in a different direction, it's probably shifting in a direction towards supporting something like this. I worked in this body when something like this would never be considered, and now we are. And you're seeing people being put into office who support such concepts. And their constituency is saying, this is where we stand, on and for the bill.
Further discussion, House Bill 152. Senator McEwen.
Thank you, Mr. Chairman. As I listen to the debate, it appears to me, once again, just my opinion, that the short pole or the long pole in this tent is the definition of when life begins. It's not a religious issue. It's nothing like that. And some of the logic I've heard appears to me to also be circular. We want to go to Article 1, Section 38, and we want to say these precepts give us how we're supposed to view this. And it's very well written, but it all comes down to the decision of when does life begin. Because if life begins at conception, the baby has Article 1, Section 38 rights. So if we protect the baby based on that belief, we're not stripping the mother of any of her rights. If we define life beginning at a different time, then maybe we are. But at the end of the day, as we look at this, the question is, when does life begin? This isn't about religious beliefs, conservative, liberal beliefs. It all comes down to when does the life begin? And if we can grapple with that and come up with an acceptable answer, everything else is already in place. Article 1, Section 38 is in place. We have statutes against murder. It's in place. We have statutes against all the other crimes that could happen. What we don't have, and I think the biggest frustration here, is a definition of when life begins. If we could solve that question, if we could answer that question, we'd never debate this again. Thank you, Mr. Chairman.
Further discussion. Senator Steinmetz.
Thank you, Mr. Chairman. I'll try to bring us home. I just wanted to answer the one question that the definition of the life of the mother is not found on page 8. And it says exceptions to abortion, prohibition, and applicability. And it's in Romanet I, lines 7 through 17. It shall not be a violation of WS 356123 for a licensed physician to perform a pre-viability separation procedure necessary in the physician's reasonable medical judgment to prevent the death of a pregnant woman, a substantial risk of death for the pregnant woman because of a physical condition or the serious and permanent impairment of a life-sustaining organ of the pregnant woman, provided that no separation procedure shall be deemed necessary under this paragraph unless the physician makes all reasonable medical efforts under the circumstances to preserve both the life of the pregnant woman and the life of the unborn baby in a manner consistent with reasonable medical judgment. I hope that puts that to rest. And then it is also to an exception to provide medical treatment to a pregnant woman that results in the accidental or unintentional injury or death of an unborn baby. And with that, Mr. Chairman, if we're done discussing, I'd call for the question.
Senator Nethercott?
Thank you, Mr. Chairman. And good senators, I really am trying to work this bill authentically for the people of Wyoming because these are real concerns. So I was aware of the definition on page 8, lines 7 through 17, which, as the good senator from Sheridan County identified, is inconsistent with another section of the bill draft. And so that there is a problem with the bill, and there are conflicting statutes that say different things. But one thing that is introduced in this section on line 7 is a pre-viability separation procedure. Is that an abortion? Is that what we're calling? Is that a new definition? This is a new term, a pre-viability separation procedure. What is that? And then it requires it to be pre-viability. And so now we're going back to this question of what is viability and when does viability occur? And of course, that's changing. To my knowledge, viability happens about 20 weeks-ish. So after 20 weeks, the mother's life is irrelevant to the question. And I heard that the baby can't live without the mother. Get it? Got it? But 20 weeks is viable and can live in a NICU, survive in a NICU. And so if the mother's life is in jeopardy, this procedure, if it's beyond 20 weeks, and as that technology and our advancements in medical procedures continue to move forward, is not available to save the life of a mother. We just need to have this clarity in place. If that's not our intent, then we need to provide further amendments to clarify that. I also just want to point out to you kind of a unique area that this law presents. So on line 13, this allows for it if the mother's life is in danger, as long as it's pre-viability, and provided that no separation procedure shall be deemed necessary under this paragraph. So we are legislating medical procedures, what are necessary and what are not necessary. I mean, this is a pretty bold move on our parts. On line 13 there, when it says this shall not be deemed necessary unless the physician makes all reasonable medical efforts under the circumstances to preserve both the life of the pregnant woman and the life of the unborn baby in a manner consistent with reasonable medical judgment. And, you know, I get that. So even if her life is in jeopardy, the physician has to make all reasonable efforts to save them both. Likely the circumstance at that stage in the pregnancy, that this wasn't a, oops, I didn't know I was pregnant when you're 6 months along and your life is in jeopardy and you're obviously receiving medical care for that and things have gone really poorly, that all of a sudden you decide you want an elective abortion. No, this is a medical procedure, things are serious, your life is in jeopardy, and likely that is a very urgent and emergent situation, not one that you go home and think about. It is ER situation, we're saving her life or not. So I just want us to be cautious about that, recognize that there is some high burdens there for our physicians in our state to evaluate at risk of being felons. And so that's a tough situation to be in. Again, I'm just trying to work through the details of this bill to understand these circumstances because we'll be asked to explain them later.
Senator Kolb.
Thank you, Mr. Chairman. Well, I'm not Dr. Kolb, but I can read. So I did a little research on this while I was trying to understand this very important question about pre-viability separation. Well, that appears to be a situation that's ongoing during a pregnancy. That isn't for 20 weeks or 5 days or 9 months. It's an ongoing evaluation of what the situation is. by a physician, taking reasonable precautions. So as I like to, I respect other folks' opinion, but I think I'm cursed with the ability to read. And that seems to be what that has to be talking about. So I think whether this, I wouldn't have wrote a bill like this myself. Maybe I would have, of course, done it a little bit differently. But we have a bill in front of us. Why? Because Supreme Court. So I suppose at the end of the day, this is why we get paid the big bucks. We come down here and represent our people. Don't represent a religion. Didn't consult with one. But I have my own morals, my own moral compass. My moral compass says the choice is now in front of me, and what will I do? And if the bill needs to be worked on a little bit to make it better, I'm all for that. But I am for this bill and would stand in favor of it. Thank you, Mr. Chairman.
Okay, thank you, Senator. Are you ready for the question? Question has been called on House Bill 152. All those in favor of Senator Steinmetz's motion that when the committee of the whole rise to the report, to do so with a favorable recommendation of House Bill 152, please say aye. Aye. Any opposed, no. House Bill 152 has passed committee of the whole. I had a hunch that the good senator in the back might be wanting to take a 10-minute break. So Senator Hicks.
Mr. Chairman, I move that the committee of the whole stand at ease to the sound of the gavel.
You've heard the motion. All in favor, say aye. Or do we need that? Okay. We are at ease for the next 10 minutes.
Yeah, you got 10 minutes.
Welcome back, Senators. The next House bill for our consideration is House Bill 222. Would the reading clerk please read the bill?
House Bill 222 engrossed. Colorado River Advisory Committee, sponsored by Representative Summers, an act relating to water, was referred to Committee Number 5, which returned a committee recommendation that it do pass. Ayes Senators French, Hicks, Ide, Kolb, and Steinmetz. Was re-referred to Committee Number 2, which recommended that it do pass amended. Ayes Senators Anderson, Guru, Kinski, and Salazar. Excused Senator Nethercott. Senator Kinski, Chairman.
You've heard the reading of the bill. What is your pleasure, Senator Steinmetz?
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report it, do so with a recommendation that House Bill 222 do pass. And for an explanation of the bill, I call on Senator Hicks.
Senator Hicks.
Mr. Chairman, there is a standing committee amendment. Could I have that read in at this time?
House Bill 222, Standing Committee Amendment Number 1 to engrossed copy, page 8, line 6, after.
Senator Hicks.
So, Mr. Chairman, there was also a Committee of the Whole amendment. If I could have that read in at this time.
Absolutely. Oh, one at a time.
One at a time?
I've been corrected, Senator Hicks. Let's deal with the bill and the Standing Committee
All right.
Amendment, and then we'll come back to Committee of the Whole.
Mr. Chairman, we can do that. And so, Mr. Chairman, I'm going to go in and explain what the bill is. So currently, the governor has assembled the governor's task force or policy, not really a policy group, but established a working group on Colorado River issues. And basically what the bill does is go in there and take most of the framework for that advisory group that the governor's put together for the last 2 years and just puts this into and codifies this group because the issues on the Colorado are not going to go away. So it makes this into a statutory advisory committee. So, Mr. Chairman, what it does, it just goes in there and establishes the advisory committee, and then they're made up of a number of different individuals, and you can find those starting on page 3. It's got 2 members of the Agricultural Committee from the Upper Green River Basin, 1 member from the Lower Green River Basin, 1 member representing agriculture in the Little Snake, which is the largest tributary to the Green, 1 member representing municipal water users, 1 member representing municipal water users that are within the basin, 1 outside of the basin, 2 members representing industry, a lot of industry representation and water users over there in the Green River, and then 1 member representing recreation, wildlife, and environmental issues, and then 1 member representing conservation districts. Mr. Chairman, it just goes into the bill and establishes the roles and the responsibilities of the members of the advisory committee to deal with all those issues that are going to arise in the Colorado River. Mr. Chairman, provides that the state engineer shall apply an employee, which they currently staff the committee for the governor's committee, and then just provide information. Provides that we have to follow the Wyoming Colorado River Advisory Committee shall not be considered an agency when we get to 4111-303 under Title 41, which is water law. And then it provides an additional 1 FTE for the purpose of working and serving this committee and also working on those other Colorado River issues. Mr. Chairman, if you get to section 2 on page 7, that brings in the 1 FTE, a $200,000 appropriation. You go over to page 8, Mr. Chairman, and it also talks about this appropriation being included in the standing budget. Mr. Chairman, the standing committee amendment was the intent of the sponsor of the bill that this be biennialized. So what the standing committee amendment says is there will be appropriation of $200,000. The standing committee amendment says that number shall be biennialized in the standard budget of the state engineer's office. So, Mr. Chairman, I'd ask for favorable consideration of aye vote on standing committee amendment number 1 to House Bill 222, and would stand for any questions.
Does everyone understand the Standing Committee Amendment number 1 to House Bill 222? Any discussion? All those in favor of Senator Hicks's motion to adopt Standing Committee Amendment number 1 to House Bill 222, please say aye. Any opposed? No. That the Standing Committee Amendment has passed. We're back on the bill, Senator Hicks.
So, Mr. Chairman, I would move Committee of the Whole Amendment number 1 to House Bill 222 and ask for your favorable consideration. So, could I have that read in?
Let's have that read in. Thank
House
you,
Bill
Senator Hicks.
222, Committee of the Whole Amendment Number 1 to engrossed copy, page 1, line 4, after.
Now I'll let you move that, Senator Hicks.
Thank you, Mr. Chairman. I move Committee of the Whole Amendment number 1 to House Bill 22 and ask for your favorable consideration. We just go into the, Mr. Chairman, we just go into the title and it says.
Senator
after-
Hicks, I believe you said House Bill 22, and I bet you that's what Senator Pappas is up to remind it is 222, House Bill 222.
Mr. Chairman, I move that caliber 222. It's a
I think
little
you got
bigger
the-
than 22. We're going after the big fish with the 222.
Okay, Committee of the Whole Amendment to 222. Thank you,
All right.
Senator. Please continue.
Mr. Chairman, under the appropriation of the title, this will require a report by this committee back to the Select Water Committee. It does have a sunset date on that, but that report would sunset in 2028, would no longer be required. Mr. Chairman, just for some clarifying languages, page 2 on line 18, it's actually the 1922 Colorado River Compact. Page 2, line 19, it's the Upper River, or the 1948 Upper Colorado River Compact. It does go in and reduce the number of members of the committee representing agriculture. It eliminates one of those positions, which there was 2 in the existing bill for everything above Fontenelle. So there'll be 3 representatives of agricultural water rights holders in the basin, 1 above Fontenelle, 1 below Fontenelle, and 1 from the Little Snake. So it eliminated one of those positions. Mr. Chairman, it also provides, if we get into page 4 on line 22, we want to insert that there would be 2 legislators, 1 from the House, 1 from the Senate. They would be appointed by the President and the Speaker and would serve during the terms of their elected duty in office. Mr. Chairman, it goes on and then just provides under page 5, line 16, that the committee shall elect a chairman and a vice chairman. And on page 6, line 1, it brings in and just provides some additional clarification of the duties, which is to include evaluation of compact obligations and water administration in light of Colorado River. Mr. Chairman, on page 6, line 15, it deletes may. This is the position authorized within the bill that says it shall staff this advisory committee. Mr. Chairman, that's Committee of the Whole. I'd stand for any questions on Committee of the Whole Amendment number 1.
Any questions? Senator Ellis.
Thank you, Mr. Chairman. I had a question about the reimbursement. For the rest of the members that are appointed to this group, they're reimbursed as other state employees are. And I've noticed this in our statutes. We have times in our statutes where we say reimbursement shall be done as we do for state employees, and then other times it says members of this whatever group shall be entitled to compensation as legislators receive it. And so we have a distinction in here, so I'm wondering if the bringer of the amendment could explain the difference between those two. And then just again, is this a new, different practice, or is this something that is already in effect, having legislators on this advisory council? We've had this discussion before in this chamber, but I would like a little just discussion on the appropriateness of having legislators on there.
Okay, any further questions we're on the Committee of the Whole Amendment number 1 to 222. Go ahead, Senator Hicks.
So, Mr. Chairman, I'll take a stab at this. So it does provide for per diem for those legislators serving on that committee. That's consistent with what we're doing right now. And as far as those other members that are appointed by the governor that are non-agency folks, they're currently being reimbursed through the governor's office for participation on that committee. So we anticipate that that would move forward. I hope that addresses my colleague's question, but if not, I'll certainly take another stab at it if we can provide some clarification.
Are you ready for question on the Committee of the Whole Amendment? All those in favor of Senator Hicks's motion to adopt Committee of the Whole Amendment number 1 to House Bill 222, please say aye. Any opposed, no. The Committee of the Whole Amendment has passed. We are back on House Bill 222. Questions, discussion? Senator Ellis.
Thank you, Mr. Chairman. I'm looking at the applicability of the Public Meetings Act, and I'm just making sure I'm looking at the right bill. Late in the day, am I looking at introduced or engrossed? Just wanted to see if that also covers, or I guess I'm curious about, I don't see it in the engrossed version, the applicability of public records. Any work that this committee does, I'm just curious if they are also exempt, or is the intent is to exempt them from certain provisions of the Public Records Act.
Further questions of the floor sponsor of House Bill 222? Further questions? Okay, Senator Hicks.
Mr. Chairman, I caught part of the question, so I think the answer is any of the work done here applicable to the Public Records Act? And the question would be yes, because it's staffed by a state agency, and it's a statutory committee now, so we'd be subject to the Public Records Act. That's my understanding.
Further discussion? Are you ready for the question? All those in favor of Senator Steinmetz's motion that when the Committee of the Whole rises report, it do so with a due pass recommendation on House Bill 222, please say aye. Aye. Any opposed, no. House Bill 222 has passed Committee of the Whole. The next bill for our consideration is House Bill 76. Would the reading clerk please read the bill?
House Bill 76 engrossed, Licensing Board's amendments, sponsored by Representative Zwanitzer, an act relating to professions and occupations. It was referred to Committee Number 5, which turned a committee recommendation that it do pass amended. Ayes, Senators Hicks, Kolb, and Steinmetz. No, Senators French and Ide. Senator Steinmetz, Chairman.
You've heard the reading of the bill. What's your pleasure, Senator Steinmetz?
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report, it do so with the recommendation that House Bill 76 do pass, and there is a standing committee amendment. I'd ask it be read in at this time.
House Bill 76, Standing Committee Amendment Number 1 to engrossed copy, page 1, line 1, delete.
And I would go ahead and move Standing Committee Amendment Number 1 to House Bill 76. And for an explanation of the House bill and the Standing Committee Amendment, I'd call on Senator Baldwin.
Senator Baldwin, good to have you back. Tell us about House Bill 76.
It's so good to be here, Mr. Chairman. I just can't even express to you. This is senators, you may remember sometimes some older senators in here may have talked to you about signing on as co-sponsors of bills and forgetting that you co-sponsored them. This is one of those. The other co-sponsor happens to be sitting in the chair right now. With that in mind, I was unable to attend the committee meeting, but I know a lot about this bill. If you happen to have the bill in your hand, it's House Bill 76, talking about licensing board amendments. Initially, this bill was brought with a number of entities within the bill. As a matter of fact, I counted them, and I believe there were 9 different entities, including pharmacy, manufacturer, retailers, real estate, hearing aid dealers, dental examiners, barber examiners, respiratory therapies. You get the things in here. And what I understand in the committee discussion, there was a lot of problems with most of the languages in the bill dealing with all of those boards. Some of those items were constitutional issues and some other things. So what the committee did is they brought an amendment, which you've been introduced to briefly. What that amendment does is take out all those parts that there were problems with, and it left a couple of paragraphs in the bill. The bill's still intact. However, if you turn to page 4, that paragraph, you see there lines 1 through 6, that stays in place. And then if you turn to page 8, starting at line 7 through line 14, that paragraph stays in place. Other than that, most of those other things are taken out of the bill, except for the repealers and the effective date. Now, what those 2 sections that were left in, they're important. And actually, one of those, I believe, was the precipitous for this bill being brought. It has to do with the cosmetologist. The issue being that right now, their rules say, the statute says that they will test every 6 months. And when they do that test, a member of the board has to be at that test to administer the test. And so what this bill does is it takes that line out of that paragraph that you read. It says that they have to test every 6 months, but that they don't have to be there in person. And what this does, in most professions right now, administer tests and administer their certifying exams by computer. So that candidate for that position could go to the community college in Riverton, in Rock Springs, wherever they're at, take that test without a member of the board actually being there. It maintains the integrity of the test. It just makes it more possible for that test to happen without the board incurring all the expenses traveling the state, which they couldn't do right now because the interstate's closed. But it brings them on par with all of the other, most of the other licensing boards and most of the other professions. So that's the first thing that happens here. The second impetus of this bill has to do with veterinarians. The veterinarians have a loop right now, a loophole, and that loophole is their rules and their statutes say when they bring somebody in for a license, when you come in from another state, the rules say if you've taken their exam within the last 3 years and you have practiced for the last 5 years, there's a 2-year period in there sometimes where people were falling into. They took the test maybe 4 years ago. They haven't practiced for 5 years, which means that interim time they end up having to sit. They can't practice in Wyoming. They can't get a license. The only thing that the board could do was deny their license. So what this does, instead of making it 5 years and 3 years, it makes it consistent and says 3 years and 3 years. If they've taken the test within 3 years, they've practiced for 3 years. Obviously, they just took a test 3 years ago. They can then have that license. So it gets rid of that loophole, that period in between where they couldn't practice. It just gets rid of that discontinue, I can't even say the word, that problem with their licensing. It just closes that up. So now it's 3 years and 3 years. And that's what the bill does now. It's a good bill. It's important, particularly for cosmetology, and takes care of something that they were having a problem with. People were not able to take the test right after they graduated. They had to wait until somebody was available from the board to then go up and give a test. Now anybody that passes their course, is ready to practice, can take the test right then and right there, wherever they are in the state. So I would urge your aye vote on this. It's a real simple bill. Instead of however many pages it is, I believe now it's a 2.5-page bill.
Senator Baldwin, that's what's left in the bill. Would you like to deal with the standing committee amendment now?
Oh, absolutely. And I believe that amendment has been moved and read in. And I believe
It has, and any explanation? If not, any questions on the standing committee amendment? Well described by Senator Baldwin. Go ahead, Senator Ellis.
Thank you, Mr. Chairman. I'm so sorry. I'm just not following along. I'm reading the bill, and then it looks like this guts all of it entirely. And I just heard a good reason for the cosmetologist to not necessarily have to have board members being present for the administration of a test. But it seems like this amendment gets rid of it. So I'm so sorry. I'm just not following along.
Senator Baldwin, does it get rid of that?
it does not, Mr. Chairman, that it leaves in. That's the one thing that it does leave in one of the two things it leaves in the bill is the cosmetology. Let me go to the page for reference on that. I have dog ear, actually I didn't, the good chairman of that committee dog eared this for me. Page 4, it leaves that section in starting in line 3, examination shall be held at least 6 times a year at a time and place designated by the board, and then it strikes out the sentence, the examination shall be conducted by the board of a majority thereof. So it takes away that responsibility that they have to actually be there to administer the test. That'll be done computerized, it will be done from here. So that left in. And the other piece that changed was there on page 8, that changing the 5 and 3 to 3 and 3. The remainder of the bill on that amendment was removed, and that just left those 2 sections in, and that's what the bill does.
Okay.
And with that, I would ask for an aye vote on the amendment.
Thank you, Senator. Anything else? All those in favor of Senator Steinmetz's motion to adopt Standing Committee Amendment Number 1 to House Bill 76, please say aye. Aye. Any opposed, no. Standing Committee Amendment has passed on House Bill 76. We're back on the bill. Any further discussion on House Bill 76? Are you ready for the question? All those in favor of Senator Steinmetz's motion that when the Committee of the Whole rises to report it, do so with a due pass recommendation on House Bill 76, please say aye. Any opposed, no. House Bill 76 has passed Committee of the Whole. The next bill for our consideration, House Bill 171. Would the reading clerk please read that bill for us?
House Bill 171 engrossed, state land leases, sponsored by Representative Byron. an act relating to state lands. It was referred, one moment please, to committee number 5, which returned to committee recommendation that it do pass amended. Ayes, Senators French, Hicks, Ide, Kolb, and Steinmetz. Senator Steinmetz, Chairman.
You're making it easy on me. You've heard the reading of the bill. What is your pleasure, Senator Steinmetz?
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report it, do so with a recommendation that House Bill 171 do pass. And I think, Mr. Chairman, this is the end of your good little Ag Committee bills. I would ask that the Standing Committee amendment be read in at this time.
House Bill 171, Standing Committee Amendments number 1 to engrossed copy, page 1, lines 3 through 5, delete.
Back to you, Senator Steinmetz.
Thank you, Mr. Chairman. I would move Standing Committee Amendment number 1 to House Bill 171 and ask for your favorable consideration, and for an explanation of the amendment and the bill, I call on the good Senator Senator Guru.
Senator Guru.
Well, thank you, Mr. Chairman. I bring to you today House Bill 171. And if you've got a copy of it in your hands, I'm going to read to you this bill in its entirety. An act relating to state lands providing that a 30-day notice shall be given before the lease of state lands. Stop. Now, Mr. Chairman, if I can, I would like to move at this time the Standing Committee Amendment number 1 to Senate file, or House Bill 171, and ask for your favorable consideration.
Senator Guru, thank you for moving that. It was also moved in the back of the room, but
I wanted to make sure that it got
we've had two movements now. But
what this amendment does, ladies and gentlemen, is that it makes what I just said true. The only thing with this amendment, that I hope you will look favorably upon passes, the only thing that House Bill 171 does is provide a 30-day notice to be given before the lease of state lands. I urge your support, and if there, I'd be glad to stand for any questions.
any questions on the Standing Committee Amendment? Senator Scott.
Mr. Chairman, I'm going to declare a conflict of interest on both the amendment and the bill.
Okay, thank you, Senator Scott. Any other questions on the Standing Committee Amendment? All those in favor of Senator Steinmetz's motion on the Standing Committee Amendment to House Bill 171, please say aye. Any opposed, no. Standing Committee Amendment number 1 to House Bill 171 is passed. We're back on House Bill 171. Senator Guru.
Stand for any questions. As I said, now that just provides a 30-day notice, and that's all the bill does after this Standing Committee Amendment is passed.
Okay, anything else? Senator Driscoll.
Mr. Chairman, just like the good senator from Bates Creek, I will declare conflict on the bill. Thank you, Mr. Chairman.
Thank you, Senator Driscoll. All those in favor of Senator Steinmetz's motion that when the Committee of the Whole rises to report, to do so with a due pass recommendation on House Bill 171, please say aye. Aye. Any opposed, no. House Bill 171 has passed Committee of the Whole. Next bill for our consideration, House Bill 52. Would the reading clerk please read the bill?
House Bill 52 engrossed, Revisers Bill, sponsored by the Management Council, an act relating to the revision of statutes and other legislative enactments. It was referred to Committee number 2, which returned to committee recommendation that it do pass. Ayes, Senators Anderson, Guru, Kinski, Nethercott, and Salazar. Senator Kinski, Chairman.
You've heard the reading of the bill. What is your pleasure, Senator Guru?
Thank you, Mr. Chairman. I move that when the Committee of the Whole rise to report it, do so with a favorable recommendation that House Bill 52 do pass. And there are, let's see, there are 4 standing, let's see.
It looks like 4 Committee of the Whole amendments,
4 Committee of the Whole,
Senator.
yes.
And we'll have to take those one at a time.
Yep.
Would you like the first one read in?
Yes,
okay,
please.
Let's do that.
House Bill 52, Committee of the Whole Amendments number 1 to engrossed copy, page 15 after line 13, insert.
Senator Guru.
Thank you, members. Thank you, Mr. Chairman and members. I'd like to, at this time, move Committee of the Whole Amendment number 1 and ask for your favorable consideration. Folks, this is the reviser's bill, and those of you that are new to the body, we're going to explain it, and then we're going to go through a couple of practice rounds, and then we're going to finish it up. This is the bill that fixes our small little mistakes in drafting errors and when we split motions and when we add and delete things out of bills. Sometimes we don't hit it quite right and we leave a semicolon or we leave a word misspelled, or sometimes we make a small mistake and we put in the wrong year, the wrong biennium, or just technical corrections like that, and that's what this is. So let's try the First Amendment and ask for your favorable consideration. If you take Committee of the Whole Amendment number 1, look at line 12. We're just changing the dates here from 26 and 27, 2000 to 27 and 28 to the standard budget request. Also, doing the same thing on line 33. That's the only change to this amendment. I ask for your favorable consideration. Stand for any questions and look for your favorable vote.
Questions on the first Committee of the Whole Amendment? All those in favor of Senator Garew's motion to adopt the Committee of the Whole Amendment number 1 to House Bill 52, please say aye. Any
Aye.
opposed? No. Committee of the Whole Amendment number 1 has passed.
Can I have Committee of the Whole Amendment number 2 read in, please?
House Bill 52, Committee of the Whole Amendment number 2 to engross copy, page 1, line 13, delete.
Senator Garew.
I would move at this time Committee of the Whole Amendment number 2 to House Bill 52 and ask for your favorable consideration. This one just actually adds a deletion and adds some deletion lines on lines 1 and 3. And I ask for your favorable consideration.
All those in favor of Senator Garew's motion to adopt Committee of the Whole Amendment number 2 to House Bill 52, please say aye. Aye. Any opposed? No. Committee of the Whole Amendment number 2 to House Bill 52 has passed.
Mr. Chairman, can I have Committee of the Whole Amendment 3 read in, please?
House Bill 52, Committee of the Whole Amendment number 3 to engross copy, page 1, line 11, delete.
Senator Garew.
I would move at this time your favorable consideration on Committee of the Whole Amendment number 3 to House Bill 52. We're doing great, folks. On this one, we're just looking at lines 6, 7, 8, and 9 and changing the words from permittee, from participant, and also the words defined in commission and regulation. And so that's lines 6, 7, 8, and 9. And look for your favorable consideration and be happy to answer any questions from anyone, including Senator Ellis.
Senator Ellis.
Thank you, Mr. Chairman. I do have questions about this amendment. You know, and one of the highlights of my time serving has been working on something called the Scrivener's Error when it came to the Gaming Commission. And going and having conversations with LSO and the Chief Executive's office, we debated endlessly the difference between something that might be a Scrivener's error versus something that's appropriate for the reviser bill. So when I follow the changes in this bill, and I'm a dork that really actually quite loves looking at the reviser's bill, but if you look at this, this looks to me like some kind of substantive change, not a typo, not a mistake, perhaps a policy discussion that we should be having. So a little, I would like an explanation on why this is not a mistake. As I've combed through these statutes, this has never been flagged for me as something that we've changed in recent years. I think this language has existed for a long, long time. I was looking at our statutes. I think it predates 2013 when we last made substantial amendments to the then parimutuel commission. So just some discussion. Is this to me looks more substantive than a clerical mistake.
Let's go to Senator Rothfuss.
Mr. Chairman, I have a similar question, but it does seem like there are two things going on. The first is changing statute to reflect another section of statute, and then the second paragraph is an amendment that does appear to have a substantive change. And so I share the same potential concern, but my secondary question then gets to the first part, which does look like standard reviser's bill, but I don't know what the F or F and K specifically are.
Any further questions? Senator Garew.
Thank you, Mr. Chairman. Actually, I really don't have a substantive explanation other than these were just technical errors that I was given to give in this bill, that they were just changing the words permittee from participant dovetails out with the rest of the bill. as I looked at it, but that's all I have for you.
Senator Ellis.
Thank you, Mr. Chairman. So just looking at page 3, this is section 1125-104, the Gaming Commission, and it changes it to Article 3 of this chapter instead of Chapter 3 of this article. So that's the technical correction that's in the bill, but that is my question. So if you look at the first part of this amendment, lines 1 and 2, that's just a conforming amendment to capture both paragraphs, but it's the rest of the article. You know, the word participant or participant, that's supposed to be defined in commission rule. So if the commission hasn't defined it, which it hasn't, I just went and looked, I don't see that definition there. Perhaps they're asking for it to be removed because it's not defined. But again, all these should be questions for us to consider. This is, to me, rises to a level that's beyond just a mere clerical mistake. You know, if you read it in the context, they're talking about who's supposed to be permitted and get some kind of vetting before they're allowed to participate. So we have a definition of permittee and an employee of a permittee. But I think there is a question about who a participant is. Perhaps, and I'm guessing on this, I don't know, maybe they were talking about the jockeys, the people riding the horses, or something else. The commission hasn't defined this, so I think that this, to me, again, it's more of a substantive question. Since we can't answer it, it's not a clerical mistake. You know, until we figure that out, I'd urge you to vote no on this amendment.
Senator Schuler.
Thank you, Mr. Chairman. I believe it was a clerical mistake. I don't think participant was ever supposed to be in there, because I think if you take a look at participant and take a look at everybody that works within the context of maybe a track, that would include the kids out front that are taking tickets. It would include the people that are doing the concessions. It would include, you know, high school kids, you know, maybe other people that are doing pretty menial jobs sometimes, you know, that maybe are just there as a seasonal. And my understanding of this was that it was never really supposed to be in there as a participant. It was supposed to be permittee. So I believe it was an error, and I think it needs to be fixed.
Further questions on Committee of the Whole Amendment number 3 to House Bill 52. Senator Rothfuss.
Thanks, Mr. Chairman. So my sense on this is that we should probably look to a different reading and verify whether this does anything or not. A revised use bill should not be contentious. It shouldn't be substantive. If there's any question or concern, I think we owe it to the process to get to the bottom of what it does or doesn't do. As I read only the language of F, it seems to do something, and I don't know the context. And I say that because a participant is something that is then statutorily provisioned pursuant to F, and a participant, while maybe not used elsewhere in statute, is allowed to be defined through rule and regulation of the commission. So that means they could define it however they see fit, and then it's entitled to certain statutory abilities, and we're deleting that. So even if it really isn't being used, it is substantive. And that is beyond, in my understanding of the revisers bill, and loved it for a lot of years. Even if it's not important substance, a substantive change is not a revision. And from that vantage point, I think at the very least we should look to a later reading to understand why it isn't substantive, or leave it out of the revisers bill and come back at another time and fix it. Because again, it doesn't seem like it's really been holding anything up being there. So that's my inclination, is to be a little on the conservative side, as this bill is intended to do, and look more deeply into it.
Senator Grew, there are a couple of options here. What are you thinking? Senator Grew.
I have been thinking about it, Mr. Chairman, been thinking about it quite deeply. And after listening to this spirited debate on this one, I would at this time like to withdraw Standing Committee, or no, Committee of the Whole Amendment number 3 at this time.
Okay, Committee of the Whole Amendment number 3 to House Bill 52 has been withdrawn. I had a hunch, Senator. And I have a hunch we'll see that on the next reading. Back to you, Senator Grew.
I'd like to ask at this time that Committee of the Whole Amendment number 4 be read in, please.
House Bill 52, Committee of the Whole Amendment number 4 to engross copy, page 1, line 15, before.
Senator Drew.
Well, I'll give this one a try. How about look on line 14, we are just changing sections to the word chapters, and we're also doing it again on lines 23 and 24. I'd ask for your favorable consideration.
Any questions on the Committee of the Whole Amendment number 4? Any questions? All those in favor of Senator Garew's motion to adopt Committee of the Whole Amendment number 4 to House Bill 52, please say aye. Aye. Any opposed? No. Committee of the Whole Amendment number 4 has passed. We're back on House Bill 52.
Back on, yes, Mr. Chairman.
Senator Grew.
Thank you so much. Here we go. Everybody got a copy of their bill? Stopwatch is out. Here we go. Page 2, line 14 of the word reserve. Page 3, line 3, years. Page 3, line 13, Article 3 of this, and strike 3 of this article. Page 4, lines 7, changing citations, and on line 8. On line 14 of page 4, change the word insure with an I to insure with an E. On page 5, we're going to strike the word and on line 3. On line 9, we're going to add the word water. On line 16, we're going to change the word fresco to fresco spelled correctly. Then we're going to turn over to page 6 on line 8, and we are going to delete the word for. On page 7, on lines 1, 2, and 3, we are going to add the word when and strike that, and then make 2 other cite errors there that we're going to change. On line 15, we're going to change corp to corpse. That's on page 7. On page 8, we are going to go to line 16 and delete as provided in Wyoming section 23-3-310. On lines 19, we're going to strike subject to Wyoming statute 2115-105. On page 9, we're going to make no changes at all because it sets up a big change on page 10, where we're going to change on line 2 the word educational, on line 3 suitability and technology readiness, on line 7 educational availability and technology readiness including, we're striking that. On line 16, we are changing the word insured to insure. On page 11, we are changing the site reference there on line 23. And then we'll move smartly to page 12, where we're going to go to line 13 and delete section A of this section and delete that on line 13. Then we're going to move over to page 13. On line 2, we're going to add the word governance from government. On line 10, governance from government. And on line 21, we're going to change the site. On page 14, we are going to go to line 6 and change the site. On line 14, we're going to change which to that. And on line 15, we're going to change the word upon. Then on line 15, on line 3, we are going to change the subparagraph and renumber as noted. And that, ladies and gentlemen, is the reviser's bill.
Senator Grew, that might have been one of the most complete efforts ever made on the reviser's bill. Much appreciated.
And Mr. Chairman, one last thing. If you do have questions on that, on any of those, I do have cheat notes on those. So, but of course you do.
Okay.
Thank you.
Anything. Senator Ellis.
Thank you, Mr. Chairman. I just want to make sure I'm reading this right. Page 5, line 9. Account means the state drinking revolving loan account. Do we really want to change that by adding the word water? I think it's fine as it is, the state drinking revolving loan account. Senators, that's the driest sense of humor I can give you.
Is there too much water in that? Senator Grew.
No, this is page 5. No, deletion. Change is being offered to correct the name of the account to be consistent with the actual account name. I know, but I wanted to answer it for you.
All right, question. Having been called, are we ready for the question? And second reading might have some work to do there. All those in favor of Senator Garew's motion that when the Committee of the Whole rises to report it, do so with a due pass recommendation on House Bill 52, please say aye. Aye. Any opposed? No. House Bill 52 has passed Committee of the Whole. Senator Baldwin.
Mr. Chairman, I move the Committee of the Whole take up consideration of House Bill 4, Medicaid 12-month postpartum coverage, which is on general file. I believe that's non-debatable.
That is a motion made by Senator Baldwin that does not need a second, to my knowledge. And all those in favor of Senator Baldwin's motion, please say aye. Aye. Any opposed, no. No. Okay, the chair is in doubt. All those in favor of the motion to consider House Bill 4, please rise. All those opposed, please rise. The motion has passed, 16 ayes, 14 noes. The next bill for our consideration is House Bill 4. Would the reading clerk please read the bill?
House Bill 4, Medicaid 12-month postpartum coverage, sponsored by the Labor Committee, an act relating to medical assistance and services.
You've heard that Senator Hicks.
Mr. Chairman, I move the Committee of the Whole rise and report.
Motion on the floor. All those in favor say aye.
Aye.
Point. The bill is the motion, and the bill, that motion is on the floor right now. So you've heard the reading of the bill.
Mr. Chairman?
What is your pleasure? Senator Hicks.
Mr. Chairman, so we can go to rules on this, but our rules under 6-4 say motion to rise and report. A motion to rise and report shall always be in order and shall always take precedent over any other motion. So, Mr. Chairman, that's what the rules say. It's always in order and it always takes precedent.
Senator Case.
Well, point of order. I don't know if the motion to rise and report is debatable, but all we have to do is vote the same way we voted last time and we can hear it. So all those that supported that vote no.
Okay, committee, that is on me. That's what I intended to do in the first place, and that's exactly what we need to do. Thank you to Senator Hicks on that. All those in favor of the motion to rise and report, please say aye. Aye. Those opposed, no. No. The chair is in doubt. All those in favor of the motion to rise and report, please stand. All those opposed to the motion to rise and report. "14 aye, 16 no. The motion fails. We are back on House Bill 4. What is your pleasure, Senator Baldwin?
Thank you, Mr. Chairman. I move that when the Committee of the Whole rises to report, it do so with an aye vote on House Bill 4, Medicaid 12-month postpartum coverage. And I will go ahead and explain that bill. There are no amendments. The bill is fairly simple if you look at it, Senators. It's only a 3-page bill. It's straightforward. What this does is authorize and asks the Department of Health under sections 9812, 9822 of the American Rescue Plan Act of 2021 to apply for state plan amendments to provide extended postpartum Right now, those postpartum care is done for 60 days. What this bill does is ask for an extension up to 1 year. Brief explanation would be that the 1 year period postpartum is the most important period for the mom. This is a period, not just 60 days, but it's a whole period of a year. And I would give the example of a patient who was out 6 months, who had a complication, who resulted in her death. And should that happen mostly because she couldn't afford to come in and keep regular doctor's appointments. And I could give you all the information and all the mortality issues, but there's a lot. About 1 in 3 pregnancy-related deaths occur in the postnatal stage between 1 week and 1 year. And all we're asking is for that to be extended for 1 year. This does not expand Medicaid. That's the argument that I've heard, and we heard in committee a lot. This is not a Medicaid expansion bill. This doesn't add any new patients to the Medicaid rolls. All that this does is take those pregnant ladies that now have 60 days, extends them out to 1 year, an important period for those mothers. And the important thing that I like to think of here is it not just protects those mothers, but when we protect the mother, it protects the baby. Without a healthy mother, we don't have healthy babies. And with that, I would ask for your aye vote, and I believe the other committee members may want to pitch in on this.
Discussion. Discussion on House Bill 4. Senator Kinski.
Well, Mr. Chairman, I voted not to take it up, but now that we've got it in front of us, I rise on and for the bill. I'm pro-life, and that means that I support organizations that when there is a woman with an unplanned pregnancy, that they try to surround her with resources so that she can carry that baby to term and either put it up for adoption or keep the child herself. And those resources are critical to that decision. She has to know that these organizations that we support, my wife and I, a lot of us here, will surround her with love, with prayer, and the resources necessary for her to carry that baby to term and care for that baby after it's born. So what does that mean? Well, it means, for instance, that I'm led to the conclusion that where the women qualify for Medicaid for pregnancy, that I support that. I support it to the extent that a couple of these organizations have called me and said, you know, we used to be able to, when we had a woman here in front of us, we could call and there'd be a hotline and we'd get somebody to pick up and we could know right there whether she was going to be eligible for Medicaid. We could assure her she had Medicaid. Now they put us on hold. And so I intervened with the Department of Health, the prior administration, said, you need to get somebody on a hotline here. We're talking about life and death for babies. They did it, then they backslid again, and I had to intervene again. So the postpartum care is equally as important. The support that these mothers need extends beyond the first 60 days. Sometimes the women who have these unplanned pregnancies have lots of resources and family and support systems. Most often not. Most often not. And so I am in favor of this because I favor life. I want these women to have every reason to carry that child to term. And this is just one more thing that helps that happen, Mr. Chairman, on and for the bill. Oh, one more thing. I have heard this referred to as expansion. I'm going to use a proper word. That means Obamacare. This is not what that is. In fact, I asked the Department of Health, is this any part of Obamacare? And it is not. Under this Recovery Plan Act, states were funded for 12 months. Now the question is whether we will continue to allow these mothers to have 12 months. But those who try to portray this as part of Obamacare expansion, it's incorrect. You can call it what you want, but it is not Obamacare expansion. I'm sorry for the proper name, but I think it's important to draw that distinction. Thank you, Mr. Chairman.
Thank you, Senator. Senator Hicks.
Mr. Chairman, if you turn over to page 2, section 3, starting on line 19, it says there is appropriated $1,900,000 from the general fund and $1,900,000 in federal funds. I would ask this bill be re-referred to the Appropriations Committee.
Senator Barlow.
Thank you, Mr. Chairman. I believe this bill has already been to the Appropriations Committee. We could examine the record to know that. Thank you.
This was referred to Committee 2, and it's been returned to us with a do pass recommendation. Back to you, Senator Hicks.
Mr. Chairman, I withdraw my motion to re-refer.
Okay, thank you. Senator Dockstader.
Thank you, Mr. Chairman. I was an aye vote in committee on this. Comes down to a life issue for me. I have traveled over into the Eastern Bloc trying to help newborn babies, a little group of us. We take supplies in, we do all we can to make sure that they live. I've traveled into an Asian country, third world, and tried to help little babies. And I thought, why couldn't I just help the babies right here at home? I'd been ongoing having discussions with someone at home who helps newborns and brand new babies. And she kept telling me, we're missing an opportunity there to help. I said, well, you know, I'm a no vote on Medicaid expansion, always was, always will be, but that's not what this is. This is an existing population. I've got no problem standing with these newborns and their moms, because in a perfect world, we have situations where people are helped. It's not a perfect world. I often travel around the state and I hear us give the pledge. I hear these little conclusions at the end of the pledge, born and unborn. I'm standing with it because it's a life issue to me. It is about the born and the unborn for me. I stand with this bill. Ask for your vote.
Further discussion, House Bill 4. Senator Cooper.
Thank you, Mr. Chairman. I have to stand with this bill for a couple of reasons. The overwhelming input I've got from my constituents has been very much in favor of this bill. But also, I know I'm pro-life. I'm very pro-life. If you're going to be pro-life, if you claim to be pro-life, you have no option other than to support this bill. Thank you, sir.
Thank you, Senator. Senator Hutchings.
Thank you, Mr. Chair. I too sat in committee and I was a lone no vote, and I didn't plan to be cold-hearted or anything about it. I think I was one of the main people there in the meeting that asked everybody questions about this program, this process. And for me, it doesn't really have anything to do with being pro-life or pro-choice. It just had, for me, the implications of entangling ourselves with the federal government again and not knowing what the federal government is going to require of us for getting into this program. One of the main things I noticed that almost everybody that came in support of the bill was same people who were pro-choice. And I asked them all kinds of questions, and I came to the conclusion that this bill would not be good for Wyoming. And one of the main things that I did not see in committee that really pushed me over is there was not one pregnant woman or one woman, well, I guess there was one woman that did have a child or two children, but no pregnant women came forth and said that they wanted or needed this bill. So that's just my no vote, Mr. Chair. Thank you.
Thank you, Senator. Senator Pappas.
Thank you, Mr. Chairman. You know, I think this bill actually ought to be supported by both pro-choice and pro-life people. I mean, because that's not the issue here, right? The issue here, you know, the child has been born, and the mothers are the folks that are at risk, and admittedly, maybe some of the children as well. But I've seen too many women with a lot of postpartum problems, some in my family. Thank goodness we had the support from our community and our medical folks, and we had the financial wherewithal to do it, but a lot of these folks out there don't have that. Whether you're pro-choice or pro-life, it doesn't matter for this. It's not what we're talking about. And certainly for those who are pro-life, like I am, I'm not just pro-birth, I'm pro-life. I mean, we want to make sure that these young children and these young mothers are taken care of. I think it's very, very important. So on and for this bill. Thank you.
Further discussion on House Bill 4. Are you ready for the question? All those in favor of Senator Baldwin's motion that when the committee of the whole rises to report to do so with a due pass recommendation on House Bill 4, please say aye. Aye. Any opposed, no? No. House Bill 4 has passed committee of the whole. Next bill for our consideration, there are none. Senator Hicks.
Mr. Chairman, I'll try this again. Maybe you guys can help me out a little bit.
Just don't say Madam Chair again.
Mister. So I really do appreciate the debate we've had on this. I think it's good. I think anytime that we actually go through in a very, what I would say, collegial type of use of our rules and regulations and debate these things, it makes us a better body. And we all know sometimes you win, sometimes you lose. We're going to walk out of here. We're going to go down and we're going to have a good time, get a chance to meet with our colleagues, Mr. Chairman. And with that, I hope that you all come down to the Central Cafe. Mr. Chairman, I move the committee of the whole rise and report.
You've heard the motion. All in favor, say aye. Aye. Any opposed, no? That one passed. That motion has passed. Mr. Vice President. Mr. Vice President.
Dave.
I knew it. Thank you, sir.
Thank you. Clerk, please read the Senator Larson. Oh, sorry.
Right. Mr. Vice President, thank you. Privilege of the floor?
Please.
Thank you, Mr. Vice President. Alec is having a reception tonight also. I'm sorry it's the same night as our gathering, but over at the Office Bar and Grill. So I'd sure invite you to that also.
Thank you. The reading clerk will read the committee of the whole report.
Mr. President, Committee of the Whole, having had under considerations bills on general file, begs leave to report as follows. House Bill 152 engrossed, due pass amended. House Bill 222 engrossed, due pass amended. House Bill 76 engrossed, due pass amended. House Bill 171 engrossed, due pass amended. House Bill 52 engrossed, due pass amended. House Bill 4 engrossed, due pass. Senator Landon, Chairman.
Senator Landon.
Mr. Vice President, I would move adoption of the committee of the whole report.
You've heard the motion. All those in favor say aye. Aye. Opposed, no. Motion carried. The report has been adopted. Next order of business, signing of enrolled acts.
Don't do it, Mr. Vice President. Do it tomorrow.
So signed.
Tomorrow.
Can we do this tomorrow? No? Okay. With that order of business, signing of enrolled acts. Enrolled Act 72.
House Enrolled Act number 72 being original House Bill 11, an act relating to retirement providing for full-time state park ranger participation in the law enforcement plan under the Wyoming Retirement Act.
These signatures will be completely illegible. I'm about to sign Senate House Enrolled Act 72 being original Senate file. Excuse me, Enrolled Act 11, original Senate File 72. Enrolled Act 72, House Bill 11. I have so signed.
Good work.
Let me see. There you go.
House Enrolled Act number 73 being original House Bill 200, an act relating to game and fish, modifying the provisions of elk, deer, antelope, bighorn sheep, mountain goat, moose, grizzly bear, and wild bison hunting licenses issued to non-resident applicants.
About to sign. Senate Enrolled Act 73, being original. Excuse me. Senate Enrolled Act 73, being original, House Bill 200, so signed.
House Enrolled Act Number 74, being original House Bill 2, an act relating to cities and towns, providing that elected and appointed officers may elect not to receive a salary or compensation while serving as elected or appointed officers.
I'm about to sign Senate Enrolled Act 74, being original, House Bill 2.
House Enrolled Act Number 75, being original House Bill 99, an act relating to property tax, amending qualifications for the property tax refund program.
I'm about to sign Senate Enrolled Act 75, being original, House Bill 99, so signed.
House Enrolled Act Number 76, being original House Bill 276, an act relating to game and fish, providing that any shed antlers or horns on state or public land are the property of the state.
I'm about to sign Senate Enrolled Act Number 76. About to sign House Enrolled Act 76, being original House Bill 276, so signed. What's next order of business? Do we have messages from the House? Okay, I think we're done. Mr. Majority Floor Leader.
Mr. Vice President, I move the Senate stand adjourn until 10 a.m. tomorrow, Tuesday, February, what is it, 28th tomorrow? February 28th. Mr.
Announcements.
Vice President.
Senator Case.
Thank you very much, Mr. Chairman. Mr. Vice President, your second conference committee on House Bill 14 civil case filing fees amendments will meet tomorrow at 12:30 upon the noon recess, and we will be meeting in room W114.
Senator Steinmetz.
Thank you, Mr. Vice President. Tomorrow at 8 a.m., your Joint Agriculture, State and Public Lands and Water Resources Committee will meet at 8 a.m. to consider interim topics together. And then at 1 p.m. in the Capitol Extension Room 4, we will have the annual Forest Health Briefing with the National Forest Service and Bureau of Land Management.
Senator Boner.
Thank you, Mr. Vice President. Your committee number 8, Transportation, Highways, and Military Affairs, will meet upon noon recess tomorrow in room W2 and online to hear from 2 candidates for the Transportation Commission.
Senator Dockstader.
Thank you, Mr. Vice President. Your committee number 9, Minerals, meet Tuesday, February 28th, 8 a.m. in room 113 downstairs with our friends from across the hall in the same and similar committee to discuss interim topics. Thanks, Mr. Vice President.
Senator Schuler.
Thank you, Mr. Vice President. Senate Committee Number 6, Joint TRW, meet tomorrow noon recess, Capitol Extension EO5, to discuss interim topics. And then we also will meet again upon adjournment in Capitol Extension Room W06 to hear a confirmation hearing of a governor appointee.
Thank you. You've heard the motion. All those in favor signify by saying aye. Aye. Opposed, no. The Senate shall stand adjourned until 10 a.m. tomorrow, Tuesday, February 28th.